Good afternoon, please be seated. Good afternoon.
Calling case number 8831379, Nikolai Shaparov versus presiding.com.
Go ahead and state your appearances.
Good afternoon, Your Honor. Teddy Parker, Eric Pepperman, and Breanna Switzler on behalf of the plaintiff.
Good afternoon, Your Honor. Tyler Watson, Mike Esposito, Brad Johnson, Marta Dunning, and Jake Suty on behalf of Real Water. I believe we also have Eric Freeman appearing on Zoom.
Good afternoon, Your Honor. Jim Cavanaugh, Nate Arrington, and Mr. Dan Polsenberg here on behalf of defendant ETP1 DBA Terrible Herbst. Okay.
Good afternoon, Eric Freeman. Yes, I am here.
Good afternoon. Okay. So inclinations, is that fair? Okay. And I think in terms of, we'll probably at some point talk about the stuff that's been continued, but I think on the motions in limine, and you all correct me if I'm wrong, we're starting with the Real Water's motion limine number 3, is that right?
That's correct.
That's correct.
Okay, good. Okay. So Real Water motion limine 3, deny overly broad, vague, relevant mean the evidence sought to be excluded, I guess. Next 5, Real Water motion limine 5. Deny. I have a note that you all may understand better than I do. It just says, ask him at trial complaints from all the other cases, question mark.
Yeah.
I've kind of run out of memory for every detail in these. Real Water motion limine 6. Okay, yeah, so I guess overall inclined to grant it in part, deny it in part, so inclined to grant part to preclude plaintiff's counsel from expressing personal opinions regarding culpability, grant in part to exclude golden rule arguments, and I would say see the examples that are set forth. I have, I think, page 5 plus, I think maybe. The last part though, other attorney misconduct, be inclined to deny that portion's just too broad and vague. Next 8. Deny. I think I dealt with that issue in Wren, if I'm not mistaken. 10. Inclined to grant in part as to the specific testimony. And maybe we already did like Mendeglan and Bush. This might tie into one we already did, maybe, but you all can help remind me, maybe. 11. Deny. Yeah, tell I don't have a law clerk today, so it might take a little longer. Well, I think we kind of did some related to this already, but inclined to grant in part, see opposition, page 2, lines 21 through 23, reply, page 4, lines 12 through 15. Deny the remainder. Thirteen. Oh, yeah, so this was one that sparked, we had an issue the other day of whether defendants properly identified treating providers as experts. Representation was made that they didn't do any identifications on that. I'm not sure that we didn't get into whether plaintiff identified treaters as experts, which may affect things because in this one on plaintiff's opposition, page 5, plaintiff talks about Mr. Herbst, treater, Dr. Redmond, who opines about causation. I mean, is that precluded by the plaintiff's motion to limine, preclude treating doctors from causation opinions? Because I think that's kind of the blanket order I already gave, but welcome clarification on that when we get to it. There's an issue maybe in this one on baby Morales, which further in another motion by defendants refer to Severin Morales as a baby themselves. So that's a long way of saying we're probably going to talk somewhat about things. There are a number of requests in that one I'm probably inclined to deny, but I'd like to hear arguments on probably the entirety, given the issues I just talked about.
And that was number 16, Your Honor.
Oh, yes,
And I think maybe we passed over 13.
I do. I skip 13. Let's see.
As easily happens, you know.
A lot of paper.
13. This is 13. Okay, 13. Sorry. Oh yeah. Okay, this one. Inclined to grant in part as the exhibits J through O. Those are signed. Deny in part as the exhibits A through I. Those aren't signed. There's serious questions regarding foundation. But I'd be inclined to pre-admit the ones that people signed. Is 17 next?
Yes, Your Honor.
Okay. I guess we'll probably have to talk about this one. So some questions I wrote down. Shaparov kids, are they still plaintiffs? Relevance of non-plaintiff ages, question mark. Severin Morales, children, kids, baby. I guess that might be this one. Yeah, I mean, sometimes this applies to both sides. We'll hear here in a moment. You all like to take conflicting positions. in this same case, not even including other cases, so we'll have to talk about this one. Yeah. 18. Line to deny that one. 19. I. 20. Inclined to grant. Certainly in my trial in front of me, no undisclosed music clips will be played, no photos will be provided. I don't appreciate comments made in front of the jury. Ask your questions. I don't think let me be a little more term of art. I don't think a statement by counsel informing a question, a statement such as, I don't want to offend or upset opposing counsel, that's not proper. I would exclude that type of comment, certainly. A lot of plaintiffs' opposition was focused on, well, we were pre-calendar call or whatever. Calendar call certainly has already occurred. But they gave a lot of plaintiffs' arguments, inclined to grant that one. 21. Grant is unopposed. 22. Question about Blaine Jones. Speaking of, so this preclude testimony regarding prior claims or litigation. Oh, Blaine Jones, that might be a question there. Inclined to grant part overall, settlements, verdicts, judgments themselves, denying part, as I already talked, the newspaper article, I think, redacted would be appropriate, deny any remainder. But certainly want to hear about potential contradictory position regarding Blaine Jones. 23. Oh boy, lots of notes. Yeah. Okay. Dying declaration. So we'll have to argue this one for sure. Dying declaration, the law seems to indicate a subjective belief. Seems to indicate if that subjective belief is not demonstrated, then the hearsay exception wouldn't apply. So I'd like to hear about that. Going through the table on the motion on page 16 is probably pretty helpful. I rely heavily, as you probably already know, on counsels to, full candor, accurate representation statements. When that doesn't happen, it's difficult. So I want to hear about, reply and opposition about, hey, all these statements or some of the statements, or maybe none of them, or some of them made at hospice or not. Funny enough, timeline wise on hospice, I think this is, if not key, then I certainly want to hear about it, even if it's not key, but told going into hospice allegedly on August 5th, 2024, was not admitted to hospice apparently until November 18, 2024. I looked for the date of death in these and I candidly can't remember. If somebody can just tell me. What?
22nd.
November 22nd.
Happens to
Okay.
be my birthday, so.
Thank-
that's
okay.
why it sticks out.
Thank you, because it's like, oh man, the one day I wanted to know and I couldn't find it, and I mean, it might be in there, I just didn't find it, but yeah, so we'll have to argue that one. That one's 23. $25, the one after 23. Oh,
That's right.
Okay. This goes back to my lingering question on freedom provider identifications, that there was some confusion, probably still is some confusion, even on my part now. You know, were they identified as experts or not? It's a question I still have. To limit, so I would be inclined to grant this, I mean, non-reporting experts such as treating physicians, are limited to opinions that were, one, properly disclosed. There's all sorts of ways that could happen. But if they're properly disclosed, then the question is, you know, were they formed in course and scope of treatment? And if those aren't met, then generally, yeah, they're limited in their opinions. 26, deny, although a question in terms of would I should know how to pronounce his name, but Dr. Najm, would his rebuttal report still be in play if I exclude Dr. Scott Donnelly? I'm inclined to deny that with a question in that regard, I guess. 29. 29, deny, certainly if defense requests a Philip Morris jury instruction, you know, we provide that, assuming they requested and assuming language, you know, and I am able to rule on the proposed language, but deny. $32.
I think we skipped 30 on.
Like, oh, sorry. Can you all hear me still if I'm over here?
We sure can.
30. Inclined to grant in part to exclude specific examples. A reminder to all counsel, exclude evidence subject to potential opening of the door. I was reminded that I didn't also add to that. If you believe the door is open to exclude evidence, however, you are ordered to get and obtain an order for me confirming your subjective belief that that door was open. Okay, thanks. Okay, 32 next, is that right?
Correct.
Okay, thank you. Inclined to deny, and I wrote without prejudice. I mean, that's the case in all of these, but maybe more so on this one than normal. I don't believe, but I read through a lot of stuff, that the actual Costco documents were really attached to the motion. Which I make it a little difficult, but yeah, I think plaintiffs make, but happy on that one, certainly to argue if you want. But I think plaintiffs make good arguments in opposition. That's 34 next.
Yes, sir.
Okay. This may be largely, if not entirely, moot with the exclusion of Purdue, which I think would also exclude Rich rebuttal report, but if anybody believes otherwise, I definitely welcome input. If not, if that doesn't apply, likely deny it on the substance anyway, but. $37 next?
That's correct.
Yes, yes.
Oh yeah, this is the one where Real Water refers to Sever Morales as a quote baby, close quote. Inclined to deny, goes away, subject to cross-examination. With a smiley face in my note for whatever that's worth, but
There's worse emojis, Your Honor.
that's fair, yeah.
And Your Honor, I think I have good news for you. I believe motions in limine 38 and 41 are moot based on previous rulings.
Okay. Would plaintiffs agree with that?
Certainly 38 is moot, Your Honor.
Okay. And I would,
They're both moot.
say that again.
I believe they're both moot, Your Honor.
Okay, so 38 moot, 41 moot.
Just for context, Your Honor, 38, you've already ruled on the admissibility of the Bats Ludwig scoring.
Oh, yeah, okay.
And for 41, plaintiff Matthew Gonzalez, his claims have been resolved, so.
Oh, okay. Phew, yeah, that one, well, given that, I won't make it, any comment other than, that one was quite interesting, given.
Maybe tell you sooner.
No,
Sorry, Your Honor.
Yeah, I even think I printed cases for that one, but that's okay. Are those all the motions in limine ones?
Those are all, Your Honor.
Okay. We've got Pro Hoc motions. I'll tell you, my concern on those is timing. A lot of the representations, but setting all these other issues aside, timing, and then just courtroom and trial management are really issues, I think, but we can talk about that. We still have plaintiff's motion on number one, is that right?
That's correct. Doctors Atchison and Tenner.
Yeah, probably need to remind me an argument, my notes are kind of on both sides, you know, quote, I'm speculating, close quote, quote, I'm not an expert, close quote. Only 10% of such people get cirrhosis. How, if at all, is affected by the partial summary judgment order. But then also defendants do make some good arguments, so probably want more additional arguments on that one. Plaintiff's motion, let me try and keep these in a little order. Plaintiff's motion, let me 10, preclude Catherine Donnelly's opinions regarding Superfund sites for municipal water as possible causes of hydrazine formation. I'm probably inclined to grant that, and that's not to say she's precluded in her entirety from testifying. But you know, speculating there must have been, and this is kind of a quote in the depot, I think, speculating my language maybe, but quote, must have been free ammonia nitrogen found in the municipal water supply, close quote, when she didn't review any test reports. How, if at all, would be affected by the order granting partial summary judgment detailed on the pages 3 and 4 of plaintiff's reply. Reminded that the motion for partial summary judgment vis-a-vis judicial estoppel is still out there. But FREI elements, FREI, F-R-E-I case elements seem to have been met, but seems that summary judgment would, these are my notes, so you know, summary judgment on that would apply because there are no genuine issues of material fact. At the very least, as to all plaintiffs with the potential possible, note those words, exception being Mr. Herbst, and maybe even would apply as to him. You know, Williams contains language, hey, even these contradictory, you know, traversing, if you will, plaintiff's expert opinion has to be, you know, there's got to be has to be competent and supported by relevant evidence and research, must quote avoid speculation, must compare that theory to other plausible causes. And I do understand that the Supreme Court, and maybe it was Levitt, may have contradicted itself somewhat and said, oh, speculation might be okay. I don't know, but
Your Honor, were you entering a ruling on that motion for summary judgment or?
thoughts.
Okay.
Yeah, those are just thoughts. Do we have anything else outstanding?
I don't believe so, Your Honor. While you were looking, I was conferring, and I don't believe there's anything else outstanding.
I think you've got it all covered, Your Honor.
Okay, want some time to talk?
Please.
Okay,
Your Honor, we can run through the list of what will be argued and what doesn't need to be whenever you're ready.
so, bear with me. Yeah, this is what happens. Well, you might have to say, because I didn't have somebody keeping track of the ruling that I proposed, so when you read off the number, confirm, granted or denied, if you can.
I will do my best, Your Honor.
Okay.
Are you ready?
Which one are we starting with again?
Motion and limiting number 3.
Nevada beverages.
No, sorry, real
Oh,
waters. These are all
real
real water motions.
Okay. Let's see. Okay,
Okay, your inclination was to deny motion in limine number 3. No arguments necessary. We'll accept the court's inclination.
3 is denied.
Number 5. Your inclination was to deny. We don't need to argue, but I think maybe you can articulate, you had a question, complaints for all other cases. We can try to answer that if that was something you wanted, or otherwise we can just go with the.
Why don't we just go with the denial?
Okay, I know for the defense side, we're not looking to introduce any other complaints from other
Okay.
cases, so.
Okay,
Okay, next is motion in limine number 6. You had indicated that you were going to grant in part, deny in part, and I believe attorneys Parker and Johnson are ready to put a stipulation or agreement on the record as it relates to that motion.
okay.
Sure, we can do that now. I think
keep
that
the
we
record
just agreed that it applies to both sides and those types of arguments will not be presented. Is that correct?
Okay, so, and I don't know if I said 5 is denied, 6 grant part, denied in part, and subject, both sides subject to the ruling, same restrictions for both sides, okay.
Perfect, thank you, Your Honor. Next is motion in limine number 8. Court's inclination was to deny, and we do not need to have argument on that.
8 is denied.
Next is motion in limine number 10. I think that was largely just, not that argument was necessary, but just to clarify, we spoke outside and essentially what we've agreed to, and once I put it on the record, make sure that opposing counsel agrees with my representation, but there are 3 specific items that weren't opposed to, which is the scope of what we are hoping to have excluded. Location of the facility bathrooms, testimony by Michael Bush, location of mouse traps from former employee Mendagana, and papers being on the floor in the bottling area by Patty Converse. That's the scope of what we were looking for, and I believe plaintiffs were comfortable with those limitations.
Correct, Your Honor. The specific references in their motion, we are okay with excluding that material. I don't believe we presented in the first place, but just in case, and then our understanding was that you denied the remainder of the motion because they're the broad. And so we're okay with that.
Correct, so grant in part as to those specifics, and then if, to the extent any other relief was sought, denied without prejudice, okay.
Sorry. Next is motion in limine 11. No arguments necessary on that. The inclination was
to deny, Your Honor.
Okay, 11's denied.
Mhm. You ready for the next one? Your Honor?
Sure.
Okay, sorry about that.
Yeah.
Motion and eliminate 12. I think I wouldn't go as far as to call it an argument, but we're just gonna clarify. I believe only one plaintiff that was brought up in that motion is still in this case. And so, can call it argument / clarification.
Okay, so we'll need to talk about that. All right.
Okay, number 13, your inclination was to grant in part as to exhibits J through O and deny A through I. No arguments necessary on that. The parties are willing to accept.
So grant in part, denied in part as stated as to those specific exhibits.
Next is motion in limine 16. There will be argument.
Okay,
17, I believe we will have argument / clarification on that one.
okay,
18 will be argued.
okay.
19, your inclination was to deny and no arguments necessary.
So yeah, 19 was denied.
20, I believe, clarification / argument was necessary on that one. There was an inclination to grant.
Correct. Yeah. Okay,
21, I believe we agreed no argument on 21. Is that correct?
It's a non-op, so yeah.
Oh, yeah.
okay, so 21 is granted as unopposed. Okay,
22, that will be clarified
okay,
as well. 23 will be argued, Your Honor.
okay,
25 will be argued.
Okay.
26 will be argued. 29 will be argued. 30, again, there's a stipulation on that between both sides, and again, I'll have Attorney Johnson stand up and articulate that, and then we can get.
We're not gonna do that, Your Honor, so, obviously it applies to both sides, even though there's any allegation on one side. The point being is that, we don't believe, that will happen this time around, so we don't need to argue.
so I call it grant on both sides, both sides subject to it.
That's correct, Your Honor.
Okay,
Next is motion in limine 32, and my notes indicate there's not going to be any argument on that. Is everyone in agreement?
what was the inclination on it? Say that again.
Sorry, it's denied without
Okay,
prejudice, Your Honor.
deny with, okay, denied.
For 34, you thought that it would be moot or either denied on the substance, and so we'll clarify / argue that one.
Okay,
For 37, no argument necessary. For 38 and
and
41.
37, what was I inclined to do?
Deny, Your Honor.
Okay, so 37's denied.
And then 38 and 41 are moot, so those will not be argued. They're withdrawn.
Okay, so those are withdrawn as moot. Okay. Other ones, anything on the other ones?
After that, we've got the plaintiff's motion, limine number 1, which obviously we're arguing a little bit again for its questions. And then, I think that plays into the part with Catherine Donnelly, which is the amendment 10. I think you guys wanted to argue that.
I'm just looking over my notes from earlier, Your Honor.
We can find you.
Yeah, no, I'm struggling to read my own handwriting, so there's that.
I can empathize.
So, Your Honor, if the court's inclined to grant that to the extent it's limited to opinions about causation or source of hydrazine, then we would leave it on the court's inclination.
And I apologize, which one are we talking?
Oh, I'm
about?
sorry, that was plaintiff's number 10 on Catherine Donnelly, Superfund site.
Okay.
I don't want to unnecessarily restrict her ability to otherwise talk about the FDA investigations or the material that's tangential to that particular issue. But as far as the Superfund site itself goes, I'm absolutely fine not bringing that up.
About, also talked about the municipal water.
Same thing.
Okay.
We can take out, if that's okay with Plaintiffs' Counsel, if that's fair, then
If you're sticking with the court's inclination, I don't think you need argument on it.
Okay, so granted, as I stated in my initial, certainly that, to clarify, my initial does not exclude her from testifying as a whole in terms of other opinions. Okay.
thank you, Your Honor.
Uh-huh.
I think after that would be the.
Estoppel.
The associate.
Yeah, I thought it was the estoppel machine.
Which we might not need to argue depending on the court's rulings on all the various.
Okay, so we'll save that to the end too.
And then the pro hocs after that, yeah.
Okay. All right.
So, Your Honor, assuming that wraps up the list, I think we would start on motion in limine number 12.
Okay, bear with me a moment.
Of course,
I guess,
there's a lot of paper on there.
Okay,
Hi, Ron, how are you doing?
good.
Good. Jake Suty, by the way, bar number 16330. So I think this motion's pretty much been quickly resolved because there's only one plaintiff that's still remaining that was subject to the motion. It was Lorraine. She had a long last name, started with K. I think in a lot of the motions, we've just been referring to her as Lorraine K.
Okay,
And in the opposition, plaintiffs agreed not to present her cervical, like neck issues or strep throat as being related to real water. So those topics I don't think need to necessarily be argued today. The only real one that was subject to the motion that wasn't addressed in their opposition or stipulated thereto was her migraines. And so when you were granting in part or denying in part, I just wanted, I think, clarification from you on if the migraines were included in the granting in part.
honestly, I wouldn't be sure, but I'll tell you, it sounds like I would exclude that, but you could say for rebuttal.
Okay, yeah, I think we'll save that. Thank you.
Oh, yeah, you know, we've got a limited amount of time, so.
Trying to
Just
put on this.
about, yeah, sure, about an hour or so each is what we're looking at.
No worries. So, council is correct as far as, most of the plaintiffs have been resolved except for Lorraine Caliana Pruitt, which is why we call her Lorraine K. The migraines one, we believed that, so, this is a non-liver injury that they say, this is the only specified one they had in their motion. Lorraine met with our neuropsychological expert and cognitive expert, Dr. Sands. And so as we detailed in the motion, it is subject to medical expert testimony, which they didn't really refute necessarily. And so that's why we reserved on that one to not agree. I think the motion that you ruled on yesterday was to exclude Dr. Sands. You denied that motion. So Dr. Sands is still a person who can testify. And so that is why we said at this point not to exclude the migraines until we have testimony regarding her cognitive and neuropsychological opinions that relate to Dr. Sands, and if he's able to relate those or the testing data and all the fun stuff on that regard, which is why we'd ask for the specific as the migraines be not excluded at this time for lack of support in showing its inadmissibility.
Well, you have the burden, so.
Correct.
Show me that it's admissible, because it,
We have Dr. Sands. He talks about the cognitive and neuropsychological testing, as well as the impacts that they have, including different types of neurological symptoms. And so that is the expert.
Does he relate migraine?
It's, I think so. He talks about her ability to focus, and the migraines are tied to that. So I just didn't know how broad their motion was going, because she talks about her ability to focus that they also brought up in their reply, which was not brought up in the motion. And so I think that's kind of where the question is Dr. Sands talks about her neurological functioning, her ability to focus, ADHD, PTSD symptoms and stuff like that. And so there's symptomologies that overlap with migraines that he testified are related to real water. If that makes sense. Thanks.
Thank you. Any rebuttal?
Hi, Your Honor. I believe Sands is out, and I think we stipulated to paying for those damages that.
I was gonna bring that up too.
Jake, you're up. Go ahead and finish your argument.
I don't know what he would have.
Yeah,
So he's excluded? Is that
I
what you
believe
mean?
that, yeah, he's excluded at this point, so trying to,
right?
I think, hang the hat on Sands's report, I don't think is the way to be doing this, so that's, I'll rest on that. I'm just trying to be short and sweet, Your Honor.
Let's, I mean, she said he's in, I thought, but now
To be
she's.
clear, sorry, Your Honor, I forgot, the defendants actually stipulated to pay for all of the neuropsychological damages related to Lorraine and Bruce Parent, and Nikolai Shaparov. So negating the fact of calling him, but again, that doesn't preclude her from testifying as to her symptoms that she notes with her neurological conditions.
Okay, so migraines are out. Not, you know, I heard a lot of words relating to issues she has, but it sounds, even the expert doesn't sound like because migraines are a different thing, so it's not precluding her from testifying about, you know, ability to focus. It's not precluding her from testifying about other potential things, but the word migraines, that carries a lot of connotations, needs expert opinion to relate it. We don't have that, it's plain burden. So granted as to that, and the other ones that everybody agreed would be excluded anyway. Okay, next.
I believe next, Your Honor, would be motion to eliminate 16.
16, okay.
One moment, Your Honor. Court's indulgence.
Sure. Oh yeah, this goes to, I have a lingering question apparently on treating physicians, whether they're excluded as I thought I did, but
And Your Honor, I'm gonna try and be brief on this one
Okay.
because I think at this point, what we can do is answer the court's questions and move on. So let's start with the treating providers. It is my understanding, we checked this during the break, that treating providers were not disclosed as non-retained experts with the appropriate disclosures on either side.
okay. So that answers my question.
Perfect. And then, Your Honor, I took a few notes of the court's inclination. I think I'm just going to walk through those and make sure that we've addressed everything that concerns the court. You stated, well, one is precluded via the plaintiff's motion. I think we just answered that. I believe it is, you know, good for the goose and all that. Then you mentioned baby Morales. If the court has any particular questions, but reading between the lines, I think the one issue that I wanted to bring to the court's attention is that it feels now like baby Morales, as they call him, or Severin Morales, has been on trial, what, 5 times? And what we're doing is we're compounding the award that a jury may be giving to young Morales every single time that we put these pathology slides up in front of the jury. And this is a problem that gets worse every time there's a new trial.
Well, I'll tell you that I don't have an issue with the slides. The issue that I have, so you know, on the slides themselves, I disagree with your argument, but
Fair enough.
the characterization of that particular individual and, you know, references potentially to other plaintiffs who are not plaintiffs in this trial is a concern. So I cut you off.
No, and Your Honor, I appreciate the clarity because that shortens this just quite a bit. So as far as that goes, yeah, I would actually agree with the court. The reference to baby Morales, who was a toddler when the pathology slides were created, you know, when the biopsy was taken, is inappropriate, it's factually inaccurate, and it's prejudicial.
So why did you all call him a baby?
We are imperfect human beings. I can't speak for whoever drafted that motion, but I will take full responsibility for the outcome. Yeah, so I think that's something that all of us, based on what the court is saying, could be more mindful of at trial, but it is something that needs to be avoided. And then I know your court, the court asked about page 5 of the opposition. Pages 4 and 5 of the opposition are the references to Guinness, Rheingold, that whole line of, you know, that progeny of cases about prior similar incidences. As the court knows, much of that goes to whether or not there's an inference that a product is defective. And I'm going off of the bolded language from the plaintiffs themselves on page 4 here. So I think this is all moot given the court's motion for partial summary judgment on the product being defective. At this point, I think any prejudicial effect that comes out of this type of a testimony greatly outweighs the redundancy of reminding the jury that the court already decided it was defective.
Thank you very much.
Yes, Your Honor. If you have any other questions, otherwise I'll reserve.
Thank you.
Thank you.
I think we're, as far as the baby part, that's kind of the subject of 17, which Mr. Parker's handling, so I'll let him address the baby questions as part of that motion, just so.
Okay. I'll be here in a moment. So.
Exactly. Brief, so I just wanted to, when I didn't mention it to the court, I didn't want you to think I was ignoring you.
No, sure.
As far as this goes, so this motion was specifically related to Dr. Datnow, who was plaintiff's expert, who was properly disclosed. So I just want to make sure that was clear for the court that this wasn't talking about treating physicians as far as the path reports. The reason why some of the path reports are relevant was related to, I think you did cite to a treating physician.
You did, Dr.
And that,
Redmond, right?
correct, and Dr. Redmond. And so Dr. Redmond said, we're not bringing him for causation purposes. So he said, oh, you know, had I had all this, because they wanted him to say alcohol, 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 alcohol. And so we asked him, what did you know at the time? Did you know anything about real water? He said, no. Did you know that it caused cirrhosis in a 22-month-old who otherwise didn't have any alcohol in its system? Did you know about the FDA report? Did you know about this, that, and the other thing? And he said, no, but I wish I would have, because I would have considered that at the time of the injury. And that's a little bit distinctive from a causation report. And so that's exactly why I know counsel mentioned that the liability portion has been kind of done, so Guinness doesn't apply or anything like that, but they're still disputing causation as to Milo Herbst. So that's why those things are still relevant, as well as prior incidences.
Well, let's slow down back. That's okay. Back up a little, because I'm having a little hard time following. So you talked about Dr. Datnow. That's not who I was concerned about. I was concerned about Dr. Redmond. And, you know, your argument, I think, collective view, yesterday or the day before was, hey, none treaters weren't identified as experts by defendants. And then I see, well, you want to rely on, at least according to your opposition, Dr. Redmond. So do you agree that you did not identify plaintiffs treating providers as experts either?
We didn't designate them as experts. No, Your Honor.
Okay. Did you designate them in some other regard?
We designated them on our pretrial disclosures as well as in our 16.1 disclosures throughout the process.
So And I apologize, it's taken a long time, but I'm trying to figure out still. Do you want to have any of the treatment providers come in and testify as to things that would be expert opinions, such as treatments?
So our testimony, the part that we were seeking to admit is not related to causation. It's related to, it was more so in rebuttal as far as defense counsel said, you know, it's alcohol, it's alcohol, it's alcohol. And so then we asked, well, did you consider anything other than alcohol? Did you have any information on real water? And that's the course and the scope. And they said if they would have had any of that knowledge, then they would have considered it because, you know, it's definitely an item that's known to cause liver problem, but not that they actually are saying real water caused it.
This is as clear as mud to me, and I apologize, but I'm not sure you answered my question. You said a lot of words. But, and I'm gonna repeat myself, but I'm trying to figure this out because you know, you all came in and said, hey, exclude causation opinions from plaintiffs treating providers because they didn't know about real water and also they weren't disclosed by defendants. And I granted your motion. Then I'm reading this opposition that you rely on Dr. Redmond, who's a treater. And you say, well, in your opposition, he's offering causation type of opinions. And so my question then was, okay, well, if defendants didn't identify these treaters as experts, and I went through this whole spiel with your colleague on the other side yesterday that people, and I'm getting a little frustrated, so I apologize, but you have to properly disclose expert witnesses, whether they are experts who have to offer a report or whether they are experts who don't have to offer a report. And I still, as I sit here, I have no idea. Because you're not answering my question.
I apologize for that, Your Honor.
Well, it's okay, but I, you know, you're eating your time right now because I don't know.
So we're not calling any treater to give causation opinions or any other expert opinions. The sole testimony we offer is factual testimony that they were not aware that real water when they treated Milo Herbst.
Factual witnesses. Class limited to the treating providers is factual, non-expert witnesses. Fairly limited to one fact that they were not aware of real water when they treated Milo Herbst. Is that what you're telling me?
Yes.
Okay.
As far as the remainder of the motion goes, I believe your inclination was to deny except for that clarification, I guess.
And the baby issue, but we could talk about that in the next.
Yeah, the next motion was titled not calling anything baby, so that's the only.
Okay.
All right.
What I'd like to do is draw your court's attention to one issue and then ask what the court's inclination is, because I don't want to talk myself out of something good. So it's interesting that they say that they're not offering a causation opinion. the literal testimony is, and I'm quoting here, and if the court is inclined, you can go to their own opposition to real water motion to eliminate number 25.
Okay, bear with me a second and let's pause their timer. Real water.
Real water 25, the opposition. Your Honor, if I speak slower than I normally do, would you?
No,
like me to just read it?
Is
I'm sorry, are you talking about 16 still, council?
We're still on 16, but I'm
But
referring to.
he's saying there are some issues that I've, I get what you're doing.
Your Honor, how about I approach it a little bit different,
Sure.
just for the sake of time
And you
and
could
effort.
quote what you want me to
Sure.
consider.
They asked Dr. Redmond on page 65 of his deposition, page 5 of the opposition to real water motion eliminate 25. If you had all that in front of you, talking about the MMWR, the Gastro Journal or the Burke paper, you would have considered real water contaminated with hydrazine as a potential differential diagnosis.
That's an expert question, right?
Thank you. That's it. And so, Your Honor, I have to say the body of law that has been developed about non-retained experts is abundantly clear in this district. You are absolutely right. If the disclosure requirements are not met, a treating physician is limited to the four corners of the medical records and nothing more. And I think that is the appropriate response here. And so, Your Honor, it is absolutely a series of causation related expert opinions that plaintiffs have been trying to use Dr. Redmond for. I think that it's important that we exclude those. And if the court has any questions about this, I'd be happy to answer.
I agree with you asking a doctor, would you have considered this in your differential diagnosis? That's an expert opinion that was not formed in the course and scope of his treatment. Plaintiffs, what they said to me was a little more limited, which may be permissible. The representation is made that we just want the treating providers to come in as fact witnesses and say he or she was not aware of real water at the time he or she treated Milo-Hurst. I think that's probably a fair fact question and answer, but let me know your thoughts on that.
I'm struggling with that slightly because I thought there was a motion in limine to prevent any argument that treating providers did not cite real water as a cause because they didn't know about it. I'm just trying to reconcile the plaintiff's various motion requests here in my head as we talk.
Oh, so am I. You can't tell.
But being put on the spot, Your Honor, I think the appropriate response to that is that I don't know that testimony in and of itself is in any way probative. If the treating provider can't provide expert testimony on causation, can't discuss a possible differential diagnosis, can't discuss Severin Morales's pathology and what that means for Milo-Hurst. And Your Honor, I think right now is an important point. And we put this out on page 5 of, I believe, the reply, but part of the strategy here from the plaintiffs is to invite comparisons between Severin Morales and Milo-Hurst. And obviously any testimony about Severin Morales is not going to appear in those medical records. And so all of that needs to be excluded as well, because that is something that was invited by plaintiff's counsel at deposition. There was a qualified response, and unfortunately in plaintiff's opposition, you were not provided with the totality of that statement. So we provided the rest of it in reply. And what it states is, his opinion that, and I'm quoting here, stated the baby Morales cirrhotic nodule finding was pretty strong evidence to support Milo's liver problems being caused by real water.
That was Redmond.
That's
Right.
Redmond.
Yeah, that's how.
Exactly. So, and Your Honor, again, I think we're on the same page here, so I don't want to belabor the point, but this is the issue. So as far as the idea of, oh, well, we just want to bring them in to say we didn't know about real water, I don't see the point. I don't think that it's probative if you can't lean into causation opinions, and candidly, the problem there is it's very easy to get in a situation where you can't unring the bell if a treating provider presents follow-up expert testimony, either, you know, in good faith or on accident or anything else, because this is what they've been told to do at deposition. So the cleaner solution here is to grant the motion as to these issues and just preclude that testimony at trial.
Thank you. So I'm gonna ask for,
And
More
Your
argument.
Indulgence for just one
I'll
second.
go. Does anybody want to add to?
Okay, no, I wanted to make sure I addressed some issues that co-counsel raised, so
Yeah.
thank you,
So,
Your Honor.
unfortunately, I'm probably gonna call you up a second time on this because I want to so. We'll go back to plaintiff and then
Understood,
back
yeah.
to you, cause this is, yeah. Difficult, so. So the only issue for me now, on this motion is you want to be able to ask the treating providers, were you aware of real water at the time you treated Nikolai? First, I've already excluded, based on your side request, they can't testify about causation. There's a legitimate concern, even with your limited question. And the point's well taken as well, given the depots and given your side putting this stuff in front of, you know, the one example I have is Redmond. Why shouldn't I exclude even that question?
So I think, Your Honor, that question is still relevant, especially if, you know, real water, if the treating physicians are being called, we still think that that is important because the medical records make a lot of references. And so to the extent that the defendants are bringing forth all the different medical records, as far as, you know, they mentioned alcohol all over the place, that it's not left in the jury's mind that, you know, oh, real water's not in there. So clearly, you know, almost without even the doctor standing there, just reading the medical record kind of still lends that bias, and the reason why that testimony is necessary to say, hey, it's not in the medical records because I didn't know about it. And actually one of the doctors that I know you don't have in front of you was like, I would have never written a water bottle down. I don't consider that information when I'm treating. And so that's the important part, is because we have lots of medical records that, you know, both sides want to present. And so the fact that the medical records themselves don't even mention real water in it, we just need that clarification for the fact to explain and not leave the jury with confusing or question marks as, well, alcohol's in there 900 times, but real water's not, to try to suggest or imply, even without the doctors testifying themselves, that you know, okay, then because real water's in there, you know, that's not, the doctors didn't make that opinion. And so having that clarification, I think, is necessary in order to ensure that there's no bias, or otherwise the medical records aren't being used in a tactical way.
Thank you. Sir, rebuttal. Sorry.
Love being up there, Your Honor. So I see a couple of issues here, Your Honor. First and foremost is, regardless of whether or not that testimony would add value to plaintiff's case, it goes outside the four corners of the medical records. And so we're already beyond the scope of what a treating physician is allowed to opine on without the proper disclosure. So from a purely procedural standpoint, I think the facts that they're trying to elicit are moot because they go beyond the very limited nature of what a treating provider is allowed to discuss. But more importantly, what we're doing at that point is inviting rank speculation. We're talking about not misleading the jury. We're talking about not presenting bias, but we're going to let the jury guess about how correct the medical records are because that doctor had not heard of real water. I think that we're going down a very slippery slope here, Your Honor, that can be easily avoided. And that compounded with the points that I made previously with regards to the, I don't want to call it priming or, you know,
I mean, that's fair.
is it? Okay, I don't want to sound that I'm being,
You're not calling
derogatory
them
in
a
nature.
liar, but yeah, priming, preparing, yeah, that's fine.
Well, I don't want to offend oh no, you said don't say that, that's right, okay. Look, Your Honor, at the end of the day, I think this is a very simple solution to a lot of potential landmines, and I think the court's inclination is correct. We just exclude this testimony, rely on Rule 16.1 and the, you know, we all chose not to list these treating providers as non-retained experts, and we have to all live with the same result. I think that's fair.
Well, thank you. So none of the treating providers reviewed Severin Morales's slides. Both sides agree with that, right?
Correct.
Okay, so the motion is granted. None of them can testify regarding Morales's slides, none of them being the treating providers. None of the treating providers, based on plaintiff's representation, this will be an order, and orders have consequences. None of the treating providers can offer causation opinions. The treating providers are limited to, and I still think there's a disconnect candidly amongst all of us on treating providers and experts, and but as to so at most right now, and I'll trial brief on this might be helpful for me. I'm not granting it to exclude this. It's granted to everything other than essentially, you know, asking the specific question to the treating providers. Were you aware of Real Water at the time you treated Mr. Herbst? That's probably a factual question, but I also understand the concerns given the priming, and priming is a fair characterization. Then we'll talk about the baby issue shortly.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor, and I believe motion in limine 17 will be much faster.
Okay, let's see.
So,
sorry.
oh, you're fine. You're doing two jobs up there.
Okay, go ahead.
I believe your preliminary question was whether any children were still in this case. There were two claimants, the Shaparov children. Those claims have been resolved. So,
Okay.
so we're dealing with all adults. So there are no kids, babies, children, or infants of any kind remaining in this case. And any discussion of prior claimants, some of whom you're well aware, were children. Their claims can be discussed, and we're not arguing that they can't, but it can be done without reference to their age, especially when we're talking about the Loma Linda article and the children. In that context, their age doesn't need to be brought up. Age isn't probative of anything that's at issue in this case, and referring to sick babies has a prejudicial effect. But you have astutely pointed out there is an inconsistency in our position, because we do want to talk about how as it relates to motion in limine 37, which has been denied because you said it goes to the weight. We do want to be able to talk about how a 22-month-old's liver would respond differently to hydrazine, in large part because they're much smaller, and the amount that would be consumed by a 22-month-old would have a much more significant impact than an adult who weighs multiple times more. So in that context, yes, we do think it'll be important to discuss with the medical experts the difference that exists when you're talking about someone that weighs, 20 or 30 pounds compared to a full-grown adult. But otherwise, we think that all the evidence could come in without gratuitous reference to children, babies, and infants being sick, given the prejudicial effect.
Thank you very much.
Thank you.
Your Honor, I agree with Mr. Watson. This is a pretty quick one, I believe.
Okay.
The Robinson case, the Beatty case, and the Guinness case says that prior and subsequent injuries, accidents are allowed. In fact, they're allowed to show common exposure. They're allowed to show similar or defective products. That's all we're asking the court to do. I think Mr. Watson agrees that it is allowable under the case law. The only thing I would point out, Your Honor, you've already pre-admitted the FDA, the CDC documents, which mention the babies. They mention the ages. Now, when we did the case in front of you, you unfortunately had to deal with all the babies because they were all in front of you. But, Your Honor, we had teenagers in prior cases. We had teenagers after that case. And so we don't, it's not a generous use of the ages. We just show the effects of real water on the human liver, be it a kid, be it a teenager, be someone in the 70s. In fact, when we had the case in front of you, Your Honor, in the Wren case, we had a 7-month-old and we had a 70-plus-year-old person. So, Your Honor, I believe this all comes in. Your inclination was to deny it. I think the court's correct. The case law supports the court denying it.
Thank you.
Thank you.
Any rebuttal?
First, I thought your inclination was to grant it. So, it's funny what is
I
heard of different.
candidly can't remember. What
Which is fine, Your Honor. I think this is akin to the motion that was heard a few days ago regarding the discussion of whether real water is a small business or a family-owned business. It's the gratuitous use that's, trying to appeal to the jury's emotion, saying, oh, you should be really sympathetic, we're a small company, or you should feel really bad because children were injured. We agree that prior claims get to come in. No one's arguing that. We just don't want an opening statement rehashing how awful it was for these children that aren't claimants in this case, because it's gut-wrenching and it's not probative of the actual damages suffered by these claimants. Thank you, Your Honor.
Thank you. So, I was gonna say, I think, here's the order. It's denied without prejudice, because there is relevant admissible evidence that's already either pre-admitted or likely to come in that weighs against the relief sought in the motion. However, oh, and by the way, please, at some point you all do written orders for me. That would be much appreciated in case I have another trial. But in any event, I'm going to verbally say, and put this in a written order. The court cautions plaintiff's side against gratuitous use and playing on the harms or circumstances to, and using gratuitous use of the word baby or babies in particular. And court welcomes objections from the defense side if you feel that's occurring. And I will not be afraid to warn plaintiffs in front of the jury if I think that's appropriate.
Thank you, Your Honor.
Thank you. Next,
Yes, Your Honor. This is motion number 18 regarding the testimony of Jeffrey Desitel.
okay,
Mr. Desitel was an employee at Real Water in 2016 and worked there for less than a year in a quality assurance role. His time at the company largely predates the events that are in this case. At his deposition, he was asked specifically, what is your job? What were you responsible for doing? It was not looking at customer complaints. He testifies that was responsible for making sure folks showed up on time, people on the floor that worked on the line, the water line. They ensured the equipment was kept up with the maintenance and that orders were produced in a timely manner. He goes on to explain that Real Water did have a series of people who were responsible for reviewing complaints. Those were people at the front desk. So while the titles may be somewhat misleading, the actual scope of what he was responsible for very clearly was not to look at these complaints. He testified he never saw them. And then during the deposition, he was asked to look at complaints and then respond to how he would have handled those complaints if they had come to him. Purely speculative, hypothetical. It was never his job. And I believe his testimony was designated to be read in or to be played video snippets. And so that's highly prejudicial to have these questions asked when it creates the impression that he was the individual responsible for this when he wasn't. He can't speak to the process. There are individuals who did review the complaints and did respond to them. Those are the people that should be asked those questions, not a guy who had nothing to do with it and that was never his job merely because his title was somewhat ambiguous. He was assuring the quality of the workers on the line, not the complaints as they came in. And for that reason, we'd ask that it be excluded because it is misleading, it is confusing, it's not probative of the issues in the case. He really can't speak to those complaints. Thank you.
thank you.
You know,
I know you want to argue, but are you okay with my inclination?
I am very okay with it. I really want to tell you this.
Yeah.
I am fine with it.
You know, this one was clear to me, so the court denies, Real Water's motion limit 18 to exclude Jeffrey Desitel for all the reasons in the opposition. Yeah. Next.
Your Honor, the next one, so number 19 was on the papers. So the next one would be number 20. And I believe, and I don't want to speak it. Say what?
We're gonna argue.
You want to argue it?
Okay.
I don't.
It's just clarification.
So you're okay with my inclination to grant?
I'm always okay when you want to grant my motions.
Okay.
right?
So you'll have a rebuttal for me.
We will reserve.
Okay.
And Your Honor, I don't want to argue it. I understand the court's ruling. I don't think we have any issues with that. The only clarification that I was hoping to receive was in prior motions, there was a discussion about images used in PowerPoints and some that weren't going to be allowed and substituting innocuous ones. We have not done that process. We have not been able to disclose anything, and sometimes we aren't able to until, you know, we're working on these things up until the time of opening. So I just don't want to be accused of running afoul of the court's order if there's some image like that's in a PowerPoint, on a PowerPoint slide, like a rocket ship that hasn't otherwise been disclosed during the discovery timeframe. And Your Honor, I can't even say what, if any, of those will be. I just want to make sure that we're clear that this ruling isn't going to implicate any wrongdoing if you know, we have something on a PowerPoint. And I think that's both sides. It's both ways. Your Honor.
Thank you. Any rebuttal?
Yeah, Your Honor. And having never had the opportunity to try a case in this court, I guess my question is really just the court's standard practices and procedures. I actually offered to plaintiff's counsel before when we were discussing these proposed 24-hour notice period. So if they do have something innocuous and they want to show it to us at least 24 hours in advance. So we all have, there's a lot of people involved, right? So I don't know what the court's typical requirement is to show the other side, but if it's innocuous images and things like that, Your Honor, we have bigger fish to fry, so to speak, and 24-hour notice would be fine. What we're trying to avoid, based on representations I've received from plaintiff's counsel off record, I think has already been avoided. We don't have any musicians that we're aware of in this case, so I don't think music videos are coming in and all that, as sad as that may be. So if the plaintiff's position is we're worried about the innocuous images that the court referenced and PowerPoints and all that, if we have advance notice, we're more than happy to work with them. And I think that's the way the trial should be.
Thank you. So the motion's granted, and well, with the clarification that, on the other motion, my ruling still stands as to those particular images. The US rocket ship, that's fine. The other ones, no. If you do want to substitute those, then 24-hour notice to the other side of what you wish to substitute to them. 24-hour notice, that's standard for both sides. Still order now. The exception, to be clear, would be potentially, you might have somebody on the stand and I don't know that this would be the case, but you want to walk them through, something on a whiteboard or something like that.
Oh, yeah.
When they're testifying on the stand, but in terms of PowerPoints and the like, yeah, certainly 24-hour notice.
And Your Honor, for clarification, nothing in the motion was intended to touch upon whiteboard drawings or
Yeah, I
any
just
of that
wanted-
demonstrative evidence in the courtroom. So I think, yeah.
Okay. Next. 22. Yeah.
Okay, so Your Honor, the next one is Rollwater's motion in 22 to preclude testimony regarding prior claims or litigation. The court noted it was inclined to grant with the same to the same scope that you did on the prior motion. I think that's fair. You said settlements, verdicts, judgments, et cetera, are out. But you did say that you had a question with regards to Blaine Jones' testimony. So I'm standing up here hoping I can answer that for you.
I think maybe the motion might have been a little. Yeah, so the motion's, the title of it's probably too broad, I guess. Maybe preclude testimony regarding prior claims or litigation. And you all want Blaine Jones' testimony in that regard in, I think.
We do, Your Honor, when it comes to the fact, well, as Your Honor is very aware, we've set the limitation for his deposition for the subsequent testimony on the fact that he's a plaintiff. We want to be able to explore the bias that's associated with that particular turn of events. I don't anticipate that we're going to get into, obviously, the merits of his claims against Rollwater. That's a little bit beyond the need. But I think that falls squarely within what the court has already decided, because obviously Blaine Jones has not gone to judgment. There has not been a trial. So if the court's inclination is to grant according to the same terms, I would reserve.
And just briefly, Your Honor, my understanding is that it's granted in part as to the verdict amounts, but denied, similar to the Nevada beverage one, I think yesterday, denied the newspaper can come in subject to redactions.
So you make me a little nervous when you say verdict amounts, and your emphasis seemed to be on amounts. That may be inadvertent, but
Yeah, sorry.
I would say verdicts, period.
Verdicts, yes.
Okay.
You were not gonna say, Real Water has lost that's
Yeah.
not our intention in any way by
Okay.
this. No, the only reason why I emphasize that is because the underlying facts, meaning the newspaper underlying facts are in, but the amounts, the fact that there's been 4 or 5 prior verdicts, that's out. But the facts themselves, the newspaper is allowed subject to redaction.
Did I say like you have to redact it, mean confer?
Yes.
Yes, sir.
So.
And that's what we agreed to, I think, in our motion as well. And then my understanding is the court's remainder is just to deny is overbroad to the remainder. And I think we're good with all of that.
Any rebuttal?
I mean, love to, Your Honor, but no.
So to be clear, other than the newspaper article and subject to, you know, the good faith mean confer on redactions on that, settlements are out. Verdicts, period, are out. Judgments are out. Those are all excluded. So granted as to that, denied in part as to the hopefully worked out redactions on the newspaper article. The motion is a little more broad than that, certainly. So the remainder is denied, of course, without prejudice.
We'll limit the order to the court's instruction, obviously.
Thank you. Next one.
This is the meaty one. This
Which,
one will probably take a little while. This
which
is
number is it?
This is number 23.
Ooh, yeah.
So, knowing that we haven't, typically we take a break around 3. It's about,
Oh, man, that's almost 4. Wow.
yes.
We are rapidly running out of time, but yeah, I do need a break. We'll come back in 15 minutes.
Oh, great.
Thank you, Your Honor.
Let's talk about number 23.
Yes, sir.
Okay.
Yeah, the hearsay one. So obviously this one is going to be a little bit more time consuming than some of the other motions, but I'm trying to be as cognizant of our time as we can be, just because it's, you know, an hour till 5. Is there any questions that you specifically want me to address? I'm happy to address any of the moving papers, but I want to just get to what you want.
I mean, the one that would still potentially be out there, I think, would be when some of the alleged hospice or non-hospice statements were made, I think is one, but that might be more for plaintiffs, but
If you'd like, Your Honor, I can still address it, at least to the extent it was briefed in the reply.
sure.
So the main statement that we were arguing in the reply was that the opposition at page 26, lines 9 through 11. The opposition states all Milo's statements to Tevis, Sarah, Christine, and Ron Murphy were made at hospice and are admissible as dying declarations. So that was the statement that was being represented. But the issue that we have here is that the testimony that was given by these witnesses is the opposite of this. They were all indicating that they've got this information allegedly from Milo in June, which is about 5 months before Milo was placed in hospice for 2 days, I believe, before he passed away. So for example, we can go through each witness line by line if you'd like. So Tevis, for example, in the plaintiff's fact sheet that was part of the discovery process, it was indicated that shortly after Milo Herbst allegedly found out about the Wren verdict, he texted Tevis. This was discussed at her deposition, that being texted, and that she indicated that if she saw the article itself, it would have been in June of 2024. So the statement is that she actually would have heard this in June, not November. When it comes to Sarah Kalovi, his other daughter, she also indicated, she testified at her deposition that it was at around that time frame of the Wren verdict is when she heard allegedly from Milo Herbst about real water for the first time, not in November. The next is Ron and Christine Murphy. So in Ron's deposition specifically, he stated that the only time that he ever discussed real water with Milo Herbst was in June of 2024, and his wife's declaration, which was an attachment to the opposition, it was Exhibit B, states specifically on or about June 21st, 2024. So all the statements that we're talking about today are not being made in the hospice setting, and so the dying declaration doesn't apply for multiple reasons, but I want to, start there. That being said, I can dive more into the dying declaration and the analysis to that as well, if you'd like.
You're good. Thank you.
Okay, thank you.
You have that chronology? Can you put it up? So, Your Honor, the question you asked earlier today, seemed like it was a long time ago, was when Mr. Herbst died. And so I gave you the date, and that's at the end of the chart there. The earlier dates, the August date, is a date that deals with when he was admitted to Henderson Hospital and when the palliative care was discussed as opposed to any curative care, Your Honor. We put in our opposition, this is page 28 of our opposition, Your Honor. And I always think chronologies on the charts for some reason helps with me. Hopefully it helps the court. On page 28 of our opposition, Your Honor.
Oh, yeah, that, because the ops are in a different binder.
Can you put it on the screen too? Maybe? That may make it easier for the board.
Okay.
And you go to line 6 through 8. So this is when Mr. Herbst was informed that he had incurable cirrhosis.
What page was it again?
Page 28, Your Honor.
Okay.
And it says the treating hepatologist testified that death was inevitable as of June 14th, 2024. If Milo did not get a liver transplant. June 14th was the day that Milo saw the transplant hepatologist, that's Dr. Red. So it's our belief, going as far back as June of 2024. For some reason, the defendants, and I say some reason nicely, because certainly they have a reason to suggest that you should only go back to a couple of weeks or so before he passed away. But that's not the case, Your Honor. We've cited several cases that stand for the proposition that when you know that death is imminent, when you know that you're not going to live very much longer, and this is only 4 months before then.
Well, so you also have deposition testimony that I think presents a real hurdle for, well, one, we're not necessarily talking about the statement in the brief that I was concerned about in terms of it was quoted again by the defense, but set that aside.
Yes, Your Honor.
Yeah. I think there's 2 witnesses and I can't remember their names, saying, essentially up until he passed, he believed he would live. And you have case law that says what you look to is the declarant's subjective belief. So on your side, the dying declaration, probably a losing issue, candidly, unless it was made when he was in hospice, which I think that goes both ways. So if you have, if you want, I don't think you could go way back to August. But I know you put a lot of other reasons in there as well.
Sure.
So whatever you think are your strongest arguments, if the dying declaration is your strongest, and
Well, there's several, Your Honor. And you're right, we did put a lot of information in this opposition. It was a very lengthy opposition. And so we started out, Your Honor, talking about the number of witnesses who had non-hearsay evidence.
yeah, and
And
I think
certainly
I agree with
understand.
you. Yeah.
Okay, perfect. So, and in terms of witnesses, Your Honor, just so I can have the record in front of you. John Calobi, Michael Lucas, Russell Riggs, Riley Miller. In addition to Sarah, his daughter, Tevis, his daughter, of course. Your Honor, we identified, I believe, 8 witnesses who could testify to the fact that they saw the bottles in his car, 3 cars. They saw the bottles in both homes, the one in Las Vegas and the one, of course, in Hatch, Utah. So those are corroborating testimony that's not hearsay in at all.
But even a potential hearsay one, I think that stood out to me was, I forget the name of this one, but the person who said, you know, we talked about real water and the name stood out because the name stands out. I mean, it's a good name, marketing wise, as compared to something like fake water or something like.
Yes.
So you have, and that wouldn't be a dying declaration, obviously, but might fall under another exception.
So we identified dying declaration. We identified, of course, those observations made by witnesses that would not be hearsay. We also identified the general exception. And we also identified, Your Honor, the medical diagnosis reasons. So that dealt with, of course, the newspaper taking it to Dr. Redmond's office. And certainly that fit under NRS 51.115. So that's the statements for purposes of medical diagnosis. And of course, he also used his daughters to communicate with his medical physicians. So the conversations between him and his daughter related to his medical care would fit within NRS 51.115. The dying declaration is under NRS 51.335. And it says, our statute says, a statement made by declarant while believing that his or his death was imminent, is not inadmissible under the hearsay rule if the declarant is unavailable as a witness. So certainly he's unavailable, Your Honor. And certainly, Your Honor, he believed that he was going to die. There's no witness that the defendant can put up that said he did not believe he was going to die.
But see,
He had hopeful thoughts.
the burden's on you though. So when you say, well, the defense can't put anybody up, I mean, you're the one saying, hey, it's a dying declaration, so.
We are. And so typically, Your Honor, and I think you've seen this from the case law we've cited, generally these decisions are made during trial, number one. They're typically not made pre-trial. I understand the defendant's desire to have this decided before you judge the credibility of witnesses, but certainly that's one of the interesting points raised in the case law. When the court's faced with considering potential hearsay, the court is also saddled with the obligation to determine credibility of the witnesses. That's what the case law says. And we pointed to that in our opposition. Tevis and Sarah both had conversations while he was in the hospital, in hospice. And that's pointed out in our opposition, Your Honor. Those certainly fall within the dying declaration under NRS 51.335. Now, we mentioned 3, but Your Honor, I can tell that Your Honor is concerned about how far do you take this back. While we believe it goes back to August 4th, because at that point, he was not a candidate for liver transplant and he knew he had there was no other way he was going to live any further, Your Honor. So we believe as of that point, I would like to take it back to June, but I see the court's not inclined to do so. But certainly it's our belief since starting August 4th and moving towards the time he died, which is only 4 months, Your Honor.
How do you address the 2 people who said he thought he would live up until a day or 2 before, something to that?
Your Honor, you know, I actually found that to be comical because they're going to use what would be hearsay to prove something else is not hearsay under the dying declaration. I don't think they really analyzed the dying declaration in their brief. To me, they cherry-picked, the defendants cherry-picked one-liners when the court and the jury, provided the court, of course, allows it, would hear the daughters talk about what their father spoke to them about while they're in hospice. So I don't think that a one-liner in a deposition can defeat all of the testimony that Ms. Tevis gave and Sarah gave. Now, Mr. Riggs, and I don't know if you were speaking about Mr. Riggs. Mr. Riggs, there's a lot of names. Understood. Mr. Riggs also said that within a month or 2 of Mr. Herbst dying, that he spoke about his consumption of real water and that it being the cause of his injury. That's what Mr. Riggs said. So even if you don't go back to June, Your Honor, Mr. Riggs' deposition testimony says within a couple of months. And I'm looking at exhibit, it's an exhibit to our opposition. Mr. Riggs' deposition, page 50. Lines 6 through 17. The question is, but if I'm understanding it correctly, the first time Milo discussed bottled water brand Real Water was with you 2 or 3 months prior to his passing, correct? That's correct. And did he discuss at the time that was August or approximately August of 2024? It could have been, it was during the time period when he was getting drained and would have had a couple months, 3 months before he died. Your Honor, it was clear that he was not going to live much longer. He was getting drained at that time, and I think we showed the court previously a picture of him in the hospital with the extended abdomen because he was getting liters and liters of liquid drained from him periodically because of his failing organs, Your Honor, or failing liver. So, Your Honor, I think we have a significant amount of, we have at least 8 witnesses who will testify about this. Now, not all of them we're trying to get under the dying declaration, obviously. Some of it comes under the medical exception, and then some comes under the general catch-all, which we've explained at length in our opposition. But it's certainly, given the cases that we've cited, and even the defense has cited, this is generally a decision made during trial, after the court has had an opportunity, or during the time the court has an opportunity to judge the credibility of the witnesses while they're on the stand. And, Your Honor, generally, the information that is not subject to hearsay, the fact that they saw the bottles, they were familiar with the fact that he was purchasing bottles from the company or the store below his office. All of that information is corroborated through observations in addition to these dying declarations, the medical exceptions, and the catch-all, Your Honor. So it's not just one exception to the hearsay rule we're asking the court to rely upon. It's all of these, in addition to the observations. And in terms of the space below his office, Your Honor, we have the lease, so that's not a hearsay issue. We also have the fact that the length of time the lease was in effect from 2000 to 2013. We have photographs of it. All of these things are not subject to hearsay. So in terms of corroboration, Your Honor, I believe we have a significant amount of evidence. Any questions at this point, Your Honor?
No, thank you very much.
Thank you, Your Honor. Oh, one other thing, Your Honor, if I could.
Sure.
And I didn't mention this, but I wanted to because I didn't see, I see the argument, I didn't see the citation to the record. Ms. Tevis, the daughter of Mr. Herbst, Your Honor, was asked whether or not she saw him ever purchase or drink real water. And she said, this is page 45 of her deposition taken August 6th, Your Honor. It was Milo's pattern and practice to routinely get water from Terrible Herbst or Spring Valley Market Store when he's at the property. She says, yes. Did you witness him getting water from either of these stores? I did. To me, Your Honor, that's no hearsay. That's direct evidence. She would be able to testify to that in addition to the time she spent when he was in hospice.
All right, Your Honor, there's 3 main issues I want to discuss, but I'm sure we might have to go through a couple others too. The first one is I want to talk about the medical diagnosis hearsay exception. I find that kind of ironic that they're trying to hang their hat on this argument because just earlier they were trying to say, hey, we want to be able to have the doctors say that we didn't know about real water. So the hearsay exception for medical diagnosis and treatment is statements made that are reasonably pertinent to the medical diagnosis or the treatment. In other words, it has to happen in the doctor's office. They have to be telling this to the doctor. The doctors they just a few minutes ago were coming and saying they want to be able to have the doctors say they didn't know about real water. And so none of the statements fall under that category.
Well, in all candor, I think you may be wrong in terms, so you know, there is the general catch-all and you also have the medical diagnosis. And so like in this one, you know, there's probably some line where you're right and they're wrong and vice versa. But, you know, when we have, I mean, it's kind of crazy. We have pictures, or at least a picture of him literally going into the office with the paper in his hand. I mean, that seems to be pretty strong evidence of either, you know, doing that for you know, the purpose of him going, and when he told, I forget which witness name, hey, I'm gonna go see my doctor about this. I mean, that's pretty strong evidence. So I interrupted you. I apologize.
No, and I appreciate that, Your Honor. To the extent that it's regarding the newspaper article, you know, it seems like based on the other rulings, we're gonna be working through the redaction of that. So I'm not trying to necessarily get rid of that piece of evidence or some of the other pieces of evidence that Teddy was talking about. For example, some of the witnesses saying that they may have seen an empty bottle or two. That does not, you know, it's not a magic wand that will turn a hearsay statement into a non-hearsay statement, because it's still an out-of-court statement being offered for the truth of the matter being asserted. When it comes to the dying declarations, you keyed in on the right fact, Your Honor, is that there's two witnesses. It is John Kalovy and Sarah Kalovy, so Milo's own daughter and her husband, the two witnesses that actually saw, you know, the water bottles, or the one witness who actually saw Milo drinking it. They're the ones that are testifying that Milo thought that he was going to live up until basically the day he died. And that is very, very persuasive compared to just some other ancillary witnesses. And it's under the Enos case that was briefed in their reply, where it's the declarant's express belief and not a doctor's prognosis, which is the determination of the issue. So the fact that he was told in August that he should consider hospice care is irrelevant if he thinks he's going to live. If the fact that up until his doctors are basically pushing him into the hospice facility 2 days before he died, that's irrelevant too. Or the fact that he was seeking a liver transplant, it's what he actually believed, which is that he was not going to die. When it comes to the catch-all exception, you know, that is for statements that are made in circumstances that give assurances of accuracy. In plaintiff's own opposition, when they were trying to prove out the medical diagnosis prong, they use the phrase extreme confusion. They say that Milo was suffering from extreme confusion. And so the question becomes, if a man is suffering from extreme confusion, how can any of his statements during that time period, starting in June up until he died, be made in a circumstance that has assurances of accuracy? Because it's not the accuracy of the witness recalling it. You know, if Russell Riggs, being the distinguished law enforcement officer that he was, comes and says, oh yeah, you know, Milo told me this, it's the truth of the statement that Milo is proffering. And if he has extreme confusion, there's no way that they're able to overcome that hurdle. Do you have any other questions, Your Honor?
Not at this time.
Okay.
Thank you.
Oh, and
Go ahead.
Yeah.
Yeah, no, you're good.
It's regarding the Tevis Hearst testimony that was brought up right before Teddy sat down. I don't believe that testimony, she explicitly identified that she saw him purchase real water, just seeing him grab water at the store.
No, and I don't think he said that.
Okay, and I just wanted to clarify that.
Afternoon again, Your Honor. Jim Cavanaugh for ETT1 DBA Terrible Herbst. We joined in Real Water's motion to eliminate on the hearsay issues. I just want to correct a couple of things. Counsel for Real Water pointed out all the testimony that did not corroborate the dying declaration claims plaintiff are making now. And in particular, I believe it's in the papers for Real Water that, in fact, plaintiff Tevis Hearst testified that she only ever talked to her father one time ever about his consumption of real water. And it was in June of 2024. And when we further asked her about her statements in the signed fact sheets about his consumption of bottled water, she freely said that was not, I did not refer to specific real water. in my fact sheets. So that testimony is there, and I understand the judge will allow us to cross witness on those things. But just to point out, as counsel for plaintiff said, when she first was asked in deposition, suggestively, I would add, about her patronage, or what she knew about the patronage of her father for purchasing real water, she said, and she was asked about both stores, the convenience store, which Milo Herbst owned, Spring Valley Market, and Terrible Herbst generally. And she at first answered in the affirmative about both combined when asked. And then later, when asked about specifics, she completely objectively, without reservation, said she never saw her father purchase real water from Terrible Herbst or from his own convenience store for that matter. And that's the actual testimony and the actual record. And if you look at the entirety of her Tevis Herbst testimony, counsel for plaintiffs mentioned a lease that Terrible Herbst had of his property below an apartment that became Spring Valley Market. He mentioned 2013. The lease and all the records clearly show, and I believe Tim Herbst testified to that as well. That lease was up in May of 2011, completely vacated by that date. The one witness who testified that he was told by Mr. Herbst that he would get his water from a convenience store below where he lived, that location on Flamingo. He had, prior to that, said he first met Milo Herbst in 2012. After that lease had long expired. So what he was recounting had to have been hearsay. It was a conversation he had with Milo about where he got water, according to that witness that has been cited to. So again, that lease and the purchase of real water, it's a very thin argument that he ever, and there's no eyewitness testimony to it, ever purchased real water or obtained real water from Terrible Herbst while they had leased the property below it. And when we asked that witness about it, he was very unclear about, what tenant or what lessee or who he was talking about as to where Milo got that water from, a tenant or a lessee below him. That's it, Your Honor. I just want to make those clarifications. I appreciate your time.
Thank you. So you need, well, this is where sometimes I struggle with guidance versus ruling versus not saying anything. Yeah. Nevertheless, so I'm going to I'm struggling what to even call this, but call it granted in part, denied in large part, I guess. I disagree, and so it's granted in part. I disagree with plaintiff's argument that the dying declaration exception would apply based on what I have in front of me, and this is plaintiff's burden. At any point in time up until he was admitted to hospice, which was, whether you calculate 2, 3, 4 days before he passed, especially, saying things like June or August, that there's no way dying declaration applies. It is I also disagree, kind of with both sides in terms of it is subjective belief. That's the key, but circumstantial evidence can potentially indicate that. So, I mean, admission to hospice 2 or 3 days or 4 days before you pass away is strong circumstantial evidence that there may be a subjective belief. That's not really excluding necessarily anything, but letting you know at the time of trial what I'm likely to do. Observations, personal observations clearly, or, to the extent the motion seeks to exclude those, that's denied. I'm not sure it really did, but those are not hearsay. Medical diagnosis, there is an exception. It may apply to a couple of these. And again, there's this fine line between what defendants argue on that and what plaintiffs argue on that. Probably somewhere in between those. General catch-all. Also, there is trying to choose my words carefully, which I sometimes don't do. There is evidence that supports, there is, to use a word, corroborating evidence in several different forms. There's a neutral way of putting it, that would potentially support the general catch-all exception. I think overall there's more of that than I think defendants acknowledge. However, this is not a ruling saying, yeah, the general catch-all applies and everything's coming in. That's not what I'm saying. I do agree, I wish I could give you more, but I do agree with plaintiffs in large part in terms of given all those types of issues, I'm not inclined to grant exclusion at this time, so it's largely denied for that reason, because yeah, it's these key detailed minutia and it better handled at the time of trial on a lot of this stuff. So apologize for not being able to do better on that, but yeah, sure it'll come up again.
Absolutely, thank you so much.
Thank you.
Which one's next?
So on the next one, Your Honor, I believe we are in agreement with plaintiff's counsel. And I will let them confirm that this is going to be Real Water's motion limine 25 to limit the testimony of plaintiff's non-related treating providers. You may recall us talking a little bit about that today. To the extent the court is inclined to impose the limitation that the court has already imposed, and I believe it is, the parties are fine with the court's ruling that non-treating providers that were not properly disclosed as non-retained providers are limited to the four corners of the records and course and scope of treatment. And am I incorrect there, or do you agree with that?
Yes, Your Honor, I do think the devil's in the details on this, but I think this motion is largely duplicative of the one that you ruled on previously.
Okay.
We are fine.
So what number was that other one?
35, and the other one was
16, Your Honor. And And I think that the ruling on that one was treating physicians who were not disclosed as expert witnesses or precluded from giving expert opinions, including causation opinions. And we understand that's the ruling, Your Honor, and would agree that that applies here. To both sides.
So there may be ships here still somewhat, it seems, because I think what Mr. Esposito is saying. Well, let me back up. The treating providers were disclosed as witnesses, right? Everybody agrees.
Correct.
Okay. And medical records regarding their treatments were produced, right?
Yes, sir.
Okay. And so if that is the case, then the general rule, as Mr. Esposito, I think, articulated pretty well, is like they can offer, even if you didn't say expert witness in your disclosure, as long as you identify them as a treating provider and you produce the medical records, they can offer generally opinions regarding their treatment. And so you're okay with that, except I'm not opening the door back up to causation.
Yes, Your Honor. I think the better, and you described it well in the argument in the last motion, was they're entitled to testify as to facts, and we're fine with that. The facts of, what they were told, what tests they run, what they didn't know about it, Your Honor, would be our position. But going beyond that and saying it's my opinion that alcohol was the cause of his injury.
I already concluded that, right?
Yes, I just want to make sure that I'm being clear that that's my understanding of the ruling, and we're all on the same page with that.
Yeah, Your Honor, Nevada law hasn't changed in a while on this. It's course and scope, four corners of the records. Any factual questions that are related to the course of that, to those documents is perfectly fine. But if you go factual or expert, if you go afoul of the course and scope in four corners, Nevada Supreme Court has repeatedly said you can't do that.
Right, and if you don't have a report, then you can't do that. That's
Correct.
true. So let's call it granted, as articulated, with, as long as they're properly disclosed, which they have been, but they're limited to opinions formed in the course and scope of treatment, still subject to the exclusion regarding causation. Okay.
I think that's everything for that one.
Okay, what's next?
So, Your Honor, the next one is the motion limine for Dr. Najim. It's 26. Given the time constraints that we are under, Your Honor, and I understand the court's inclination, I'd like to just do a little bit of targeted argument before I relinquish my time. I've made no secret of the fact that I think Dr. Najim's recent deposition testimony, where he says he cannot plausibly determine if either of his pathway arguments could result in the amount of hydrazine that showed up in the testing, should be a basis for excluding him at trial. But I do understand, if the court's inclined to say no, that I can cross him with that, right? Yeah. So I'm not going to get into that beyond just saying my piece and moving on. The big issue that I have here, well, there's two really. First is, I do believe we need to exclude his testimony on the 10x testimony, or as to the degradation of hydrazine. He provides an opinion saying, he's a statement about, well, it could be up to 10 times the amount. I asked him about that deposition. He said that was a quote unquote placeholder value that has, and I'm quoting him here again, it was not a quantified value based on knowledge that he has. Literally a placeholder. It was a turn of phrase. And in every case that I've seen, plaintiffs' counsel have weaponized that at trial to treat it like a fact or an expert opinion. It should not be allowed to come in. It's in black and white. There's no way to interpret his testimony anybody differently. It was a placeholder that doesn't have any actual scientific value and will not assist the jury. So that's my piece on that. The other major issue we have here is the rebuttal report, Your Honor, which I candidly was very surprised to see come from Dr. Najm, because the rebuttal report talks about things like responding to customer complaints, the appropriateness of non-targeted GCMS testing in response to customer complaints, Scott and Catherine Donnelly's opinions on HACCP procedures, hazard analysis, things like that. So I asked him. And he said, and this is on page 16 of our motion, no training or education in HACCP compliance, never conducted a root cause analysis, never opined on whether or not hydrazine as a chemical in the water is a reasonably foreseeable hazard. He's never looked into the industry standards for testing in response to customer complaints. He's never done any research or done knowledge into the appropriate procedures for dealing with customer complaints. This is quite simply just not his area of expertise. And he is more than qualified as a chemist, right? My hat's off to him. He's a smart man. I was privileged to talk to him, but this is not his area. And so what we're asking for here with the not officially conceding the point on cross-examination versus the pathways, but I know where you're going. Yeah. So I'll take the loss there if I get it. But as far as the other stuff goes, Your Honor, the 10X opinion, he's admitted that's not an actual opinion. That's not an actual number, not based on anything. The entirety of the rebuttal report, we give you several pages of Dr. Najm's testimony where he details why he's not qualified to give those opinions. So we would ask that the rebuttal opinions, anything in the rebuttal report be excluded, and that any testimony relating to the degradation of hydrazine be excluded as well, because it's based on that erroneous 10X number.
Thank you.
Thank you.
Your Honor, first to correct the record, I disagree with counsel's characterization of Dr. Najm's testimony. He has
To your credit, that was a very good way of putting it. So thank you.
I've tried to heed your preferences. Your Honor. Dr. Najm stated point blank in his testimony when he was asked if his opinion was that the chemical reactions that were occurring in the electrolysis process, which is undisputed, which everyone agrees was the cause of the hydrazine in the concentrate, would have produced enough hydrazine to match those levels measured by the FDA. And he said, my opinion is that the actual measured hydrazine in the water could have resulted from that reaction. That's his testimony. He said, I can't give you an exact number. I can't measure to these exact 1.33 milligrams per milliliter, but that does not mean that he did not testify as to his pathways being the most
So
likely.
I agree with you on pathways. So you probably want to spend time about the 10X degradation and the rebuttal.
Yes, Your Honor. So on the 10X degradation, it is an undisputed fact that hydrazine degrades over time. And the rate of degradation is impossible to quantify. You cannot quantify it because it's based on various factors such as temperature, pH, air exposure, all these different factors. You can't come up with a rate of degradation. And Dr. Najm has said that. And he's never
So
said
10X degradation's out.
Well, he was giving explanation as to degradation, and he said, it wouldn't surprise me if it was 2 times degradation, and it wouldn't surprise me if it was 10 times degradation. So he's not saying, it's my opinion, that there was 10 times more hydrazine in the concentrate than at the time they made it compared to the time they measured it. That's not what he's saying. And Your Honor, I think if he gives that type of testimony, if he tries to say something to that extent, counsel can object and Your Honor can rule on it. But to limit his ability to explain his opinions at this point in time, based on characterizations of his testimony that isn't before you, I think would be improper. Your Honor, do you have any other questions on that before I move to the rebuttal?
No. Well, so my question on the rebuttal, it seemed to me that there's a very good chance the rebuttal is moot and, you know, whether withdrawn voluntarily with that or whether I order it. You know, I don't know that I need to get into the weeds of it, but if you think, oh, the rebuttal's, given my other rulings, the rebuttal's still in play, I'd be curious to hear about that for sure.
Your Honor, it's more of just a clarification on that. No, we won't call Dr. Najim in rebuttal anymore now that the Donnelly's opinions are out. However,
Not all of hers is out, okay, right?
right, her hydrazine opinions are out. And Dr. Najim isn't gonna testify on rebuttal. There's no need. He doesn't need to testify about HACCP or anything like that. However, in his rebuttal report, as part of his rebuttal, he included opinions that and statements and facts that he has testified to in every single trial, including the last trial with this counsel involved. And that's just the GCMS testing. He has testified in every trial, including the one before this court, what GCMS testing is. It's the exact same testing that he used as part of his 2 published research papers on hydrazine and testing it as a byproduct of water treatment. He testified that's what the FDA used. He testified to the GCMS testing, how it's the standard in the industry to measure hydrazine, how it's non-targeted, how it's available at labs. For anyone who wants to send out samples to have it tested. And so I just want to be clear that just because we agree that he's not going to be testifying in rebuttal based on the court's prior rulings, that they don't stand up here and say, oh, these opinions that he's testified to in every trial that he is completely qualified and knowledgeable about and is like I said previously testified. They don't come say, oh, that was mentioned in his rebuttal report, so it's out under your motion in limine ruling, which is what I fear is going to happen on a lot of these. And just before I ask if Your Honor has any final questions, I would just refer the court to page 15 of the opposition, where we cite excerpt of Dr. Najim's testimony from the last trial and Land Van Buren about the GCMS testing, to just be clear that this isn't anything new or limited to a rebuttal or anything that counsel hasn't seen from Dr. Najim and this court didn't see from Dr. Najim and hasn't been part of the prior 5 trials. So with that, Your Honor, if you have any other questions, I'm happy to answer.
Thank you very much.
Your Honor, opposing counsel says that we can object and have the court rule on Dr. Najim's testimony, and that's basically what we're doing right now. We object. So just going down my checklist here. So I'm assuming we haven't changed the court's opinion on the pathways, correct?
Correct.
Ah, shucks. Okay. Do we have a final decision on the 10X testimony based on the placeholder and no scientific value?
Yes, so he can't testify that there's a 10 time degradation. He testified he can't do that essentially. Plaintiff's counsel put it succinctly, which is additional or same reason you can't quantify the rate.
That's not true, Your Honor, and I can address that respectfully. That is something he testified to.
Well, so what did he say the rate is?
Let me pull that up.
Okay.
He didn't say you can't quantify it. He said he didn't have the information that he needed.
Oh, so he didn't quantify it.
I asked, question, what additional information would you need to work out those calculations? I would need a lot of experimental data on the concentrate product itself under different conditions to be able to establish a rate of degradation. That's depositions at page 77, 23 to 25, going into 78. He then clarified that things like the temperature of the room that the hydrazine was stored in was a factor. So the thing is, it's calculable. He just decided not to go get that information. I asked him, did you do any testing on the titanium tubes you had access to? No, I never asked that. Did you ever try and find out what the ambient temperature was where the water was stored? No. It's something he has the information to do. He has the ability to do, and certainly has the qualifications to do. He just didn't do it. So that's the difference. Dr. Najim should not be opining on degradation of hydrazine based on, well, I mean, his placeholder primarily, but speculation based on data he just chose never to go get.
Well, okay, so maybe you and I disagree a little bit. He can testify that it degrades. I mean, that you're not seeking exclusion of that, right?
Oh, no.
Okay, okay,
No, the fact that it degrades, I will stipulate to, yes, it does.
okay.
Yeah.
He just can't testify that it's some particular rate that happened here because he didn't do it. That's what you're saying?
Yeah, this whole, it could be 2 times, it could be 10 times, 100 times more potent 6 months ago. That kind of testimony that has ultimately been weaponized at trial is what we're trying to keep out, certainly.
So I'll say I disagree with you a little bit. You certainly can't say there was a particular rate here. He can say it degrades. You want to, understandably, it sounds like, cross-examine him and say, you don't know what rate it degraded at. You'll have to say yes, I think, because you didn't do X, Y, and Z. Yes. But your focus on his answer in terms of, hey, I don't know what it degraded at, whether it's 2 or 10. I don't see how that's a real issue.
Well, it's not tied to any actual data, Your Honor. There's no scientific data behind it. He even said, this is not based on any information that I have knowledge of. That's the problem.
Okay.
So I'll leave that be for a moment, Your Honor.
Okay.
I also want to clarify, as far as the rebuttal goes, I don't believe that Scott Donnelly has been excluded entirely. He has a variety of opinions that don't touch on causation at all.
I thought I excluded him, but I could be mistaken.
I thought they too.
That was not my understanding based on the scope of the motion, because we were talking about his opinions on how hydrazine is created. But if you go to his report, which is in this particular set of moving papers, he has opinions on hazard analysis, GMP audits, FDA regulations, all things that the court has said that he does actually have a background in. So if the ruling is that he's excluded in full, then, you know, potentially you have to address that via motion practice, but.
Yeah, I'm sorry, I thought he was excluded. We can do it whenever the court wants to consider it, but I thought it was that.
Somebody will have to play back for me, I guess.
Okay,
That's fine.
Your Honor, regardless of whether or not Scott Donnelly is excluded in full, the substantive issues with the rebuttal report remain. And I'm a little bit troubled about the reference to the non-GCMS testing. Let me get there. A moment, please.
Non-targeted GCMS test.
Because again, and I've read you the testimony, he has absolutely no qualifications to talk about what the appropriate response to customer complaints are, what the appropriate steps are for a root cause analysis. He testified specifically, he has no experience in that regard whatsoever. He has no HACCP training. He's not that guy. And the non-targeted testing testimony that plaintiff directed you to says, Real Water should have conducted non-targeted GCMS testing in response to one of the numerous customer complaints reporting illness. That's his actual opinion. He's not qualified to make that opinion. He said so in deposition this time. So the fact that he was allowed to testify to this in Van Buren or any of the prior cases, now we have his deposition testimony that occurred after this, where he says, no, I'm not qualified. I did not get any training or education in those areas. The fact that he knows what non-targeted GCMS testing is fine. If you want to discuss what how the testing works, what is it? What goes into it? What do you need? Fine. But when he starts talking about the appropriateness of utilizing the testing in response to a customer complaint issue, now you're going well beyond what your qualifications allow. And so again, I'm trying to be cognizant of the fact that we don't want overbroad relief, right? As we all tend to do, but this is the fact that plaintiff's counsel gets up and gives this to you as the demonstrative for why he should be able to talk about this is precisely the problem that has us arguing this motion. So when it comes to anything related to the rebuttal report, Your Honor, we would ask that it be excluded with a caveat that if Dr. Najm as a chemist wants to discuss what non-targeted GCMS testing is and what it detects and what it doesn't, and the chemist side of that particular set of testimony, we're fine with that carve out.
Don't they have,
Catherine Hutt, Your Honor.
I was gonna say, forget if she's a doctor or not, there's, but Hutt to testify to that type of issue.
They do, Your Honor, and she does, and we have not gone after Dr. Catherine Hutt's qualifications on that issue.
Thank you very much.
Thank you, Your Honor.
Okay, so working back, so the rebuttal report, so it's grant, so number 26 grant part denied in part as follows. So vast majority of opinions contained in the rebuttal report may or would be moot if I did exclude Scott in his entirety. I thought I did, but you've all seen my memory's not perfect, so we'll have to brief that. If I did not exclude him in his entirety, then the vast majority of the rebuttal is probably in play. Specifically, however, he is excluded from testifying that block quote about they should have done this based on these complaints. He doesn't have the qualifications to do that opinion. To be clear, he can testify what it is, he can testify about what non-targeted GCMS, apologize if I get that term wrong.
That was correct, Your Honor.
Okay, non-targeted GCMS testing, he can testify about what it is, how it works, what it does, what it detects or doesn't detect, what it is used for. So not excluding any of that, but what he can't do is tie it into they should have done this testing based on the customer complaints they got. He doesn't have that experience qualification. On the degradation, he can testify that hydrazine does degrade at different rates under different circumstances, and he goes through that in more detail than that. But what he is excluded from testifying is that here it degraded at 2 times or 10 times. He doesn't have a basis for that because he didn't do the necessary testing for that. At the risk of any questions.
Okay, we got it, John. Thank you.
Understood, Your Honor. Thank you.
We'll press over a bit still, I suppose. What's next?
Unless I'm mistaken, Your Honor, I think the next one is 29.
Yeah, Your Honor, we do.
Okay.
And Your Honor, I can be very, very quick about this because I believe I know where the court finds. Spent a lot of time with you today, Your Honor. The court mentioned that a Phillips Morris instruction would be something the court would consider, and I think that would have been the case regardless if the motion had been filed.
True.
Right? But problematically, though, Philip Morris doesn't require that we seek an instruction instead of a motion to eliminate. So that is an argument that was made in the opposition that I take issue with. But I think the real problem here is that the evidence of the trial strategy that's been presented so far with this particular issue contradicts Williams. If you go to pages 7 and 8 in the motion, right, we can all go there together.
Okay.
Williams expressly states the plaintiff told the jury to think about how many other Jesse Williams in the last 40 years in the state of Oregon there had been. In Oregon, how many people do we see outside driving home, smoking cigarettes, etc.? Now in Brown, we gave you multiple instances where Counsel Parker did the same thing. We know of dead pets, 3 dogs, 1 cat. Mr. Fisher in Tampa was hospitalized. Mr. Randolph's nephew and his brother-in-law got sick. Williams is saying you cannot present this testimony to a jury so that they can inflate the award based on injuries to non-parties. Now, can we give a jury an instruction that says, don't consider this? Yes, but why are we allowing testimony in that's clearly against what Williams is saying, only then to ask the jury to hopefully disregard it when rendering a verdict? And there's other case law that supports this position, Your Honor. United Healthcare is a decision that came out after the last time this court tried the case, right? So to the extent there's any argument about what we did last time, let's try it again, right? United Healthcare expressly said that basing a punitive damages award based on the conduct of the defendant towards its insurers, right? United Healthcare in that case, for context, was improper. And so to the extent that we're talking at, and this is only the punitive damages phase, remember. So to the extent that we're talking about the harm that's been done to all of these non-parties, this is the point where this is excluded. Now, Plaintiffs' Counsel points to Wyeth and says, oh, well, we should be allowed to do this. But Wyeth talks about the reprehensibility of the conduct and specifically carves it out as saying, as to whether or not, and I'm going to quote here again, to determine whether a defendant's conduct is so reprehensible as to warrant the imposition of punitive damages, a jury may consider evidence of actual harm to non-parties. Wyeth is talking about the compensatory phase there. And they're saying that, okay, if you're trying to figure out whether or not to award punitive damages, bring it on. But once we get into punitive damages, the common thread between all of this case law is do not point to people outside of the courtroom. Punitive damages is based on the conduct that was targeted towards the plaintiffs, and that's it. And so we have United Healthcare. I'm trying to get to my other case law here, Your Honor, just so I can make sure it's all on the record, but I'm sure you read the briefing. Philip Morris, and then I think there was the State Farm case as well. Ah, yes. My favorite quote. The United States Supreme Court held in State Farm v. Campbell, due process does not permit courts in the calculation of punitive damages to adjudicate the merits of other parties' hypothetical claims against a defendant. This is the part that bears reading. Under the guise of the reprehensibility analysis, took me 3 tries, but I got there. Under State Farm v. Campbell, Your Honor, the court is expressly calling out the exact strategy that is proffered in the opposition to this motion. Saying, well, it's part of the reprehensibility analysis. No, it isn't. The US Supreme Court has said you cannot pretend or you cannot hide this faulty information in that kind of an argument. And so when the conduct in question is allowed to be presented to the jury in a way that expands beyond the specific conduct to these plaintiffs, it violates constitutional protections. So yes, we could have a Philip Morris instruction, depending on how the court rules. Obviously, we have that prepared and ready to go, but we can't unring the bell. And I know that's the turn of phrase for motions in limine generally, but here it's extremely poignant. Why would we present testimony or allow testimony at all that is so clearly against what the US Supreme Court and the Nevada Supreme Court have both said is improper and a violation of constitutional protections?
Thank you very much.
I would not like to waste time sticking with its initial inclination.
You should respond.
Okay, so Philip Morris is pretty clear, and we cited in our opposition on page 2. Says evidence of actual harm to non-parties can help show the conduct of the harm. The plaintiffs also pose a substantial risk to the general public, and so was particularly reprehensible. So Philip Morris expressly says that and distinguishes considering evidence of harm caused to others to determine the degree of reprehensibility of the conduct that harmed the plaintiff. And this is all about reprehensibility. And all the comments that were cited in the brief were actually couched in reprehensibility. And it says, and I think believe in all those, it stated, this is the harm that was done. This is the reprehensibility as far as that goes. And if you look at the jury instruction during the punitive damage phase, which we also cite on page 4, it's one of the things that the jury is supposed to consider is the reprehensibility of the conduct of the subject defendant, and the punitive damages will serve the purposes of punishment and deterrence. That's the jury instruction that has been used in Wren. That's the jury instruction that has been used in Brown. That's the jury instruction that we would propose. I know that doesn't happen in this case as well. So defendants cannot meet their burden that demonstrates that all evidence of quote non-parties cannot be admissible because it's expressly permitted under Philip Morris. And like I said, we cite it several times. They also always cite to United Healthcare, and there's a really, really, really big distinction with United Healthcare. And that's the fact that United Healthcare was actually not a matter of public health at all. It was actually, quote, only entirely economic, unquote. So the court wasn't considering, reprehensibility in the same context that we're representing here. So so citing for that is completely inapposite as far as that goes. They cited that they expressly held that it was improper to base punitive damages on that, like I only aimed at teen health. Again, that's distinguishable because it's not the public health that we're talking about here. And the analysis that was going there was about the ratio of punitive damages, and Philip Morris was actually not even brought up, or that wasn't even the construct that was kind of being discussed in the United Healthcare. So it's kind of trying to compare apples to oranges. So we would say that case is inapposite to the application as it responds to here. And so the reason why we argued that it was, an improper motion in limine or otherwise not applicable at this time is because the Philip Morris instruction, we are not having arguments, they cite to a bunch of prior stuff. We're not here. It's a question by question basis. We say that it goes to reprehensibility. The context is very important. Philip Morris expressly allows this under, like I said, I don't want to read it again. So it expressly says it. So we would say that the proper thing is deny this motion right now because it's not applicable as it stands. Reprehensibility is both in the to check the box and also in the instruction as the second phase. And so that's
Now you repeat yourself, so thank you.
Yep.
As is tradition, Your Honor, shall I argue or are we? I understand.
You are more than welcome to argue. Let me put it that way.
Understood, Your Honor.
On a limited time basis.
I understand. See what I can do here. So, Your Honor, there's just a few quick points. First and foremost, plaintiff's application of Philip Morris is misleading to the extent that they try to equivocate the injuries that were allegedly suffered by non-parties with conduct generally. And I know that's a little obtuse. That is my thing, so bear with me. If you go to United or State Farm versus Campbell, Your Honor, what the court said is that there must be a nexus to the specific harm suffered by the plaintiff. only then do you evaluate the nature of the proffer of the conduct of the defendant, right? So the conduct of the defendant that comes in is, their quality control procedures, right? Did they do a recall? These are the things that we know the plaintiffs are going to say. It's fair game. But when it comes to these injuries that were allegedly suffered by other parties, that's the bridge too far. And that's the distinguishing factor. Philip Morris, State Farm v. Campbell are consistent in saying that it's the conduct of the defendant as to the specific harm alleged against the plaintiffs, not the harm alleged against third parties, not the alleged injuries. State Farm goes out of its way, Your Honor, to even discuss the fact that, I'm trying to find the quote here, Your Honor, and I apologize, but bear with me. I'm going to butcher it because we're on a time limited basis here, Your Honor, but basically, the Campbell decision goes out into some detail to describe the risks that are associated with letting this testimony in the first place because of the fact that the defendant isn't on trial for those injuries. So we're now allowing testimony to come in, inferences to be made with a defendant that can't defend themselves rightfully as to these issues. And it doesn't matter in that case whether or not the issues have been decided or not. It doesn't matter whether or not a dollar figure has been assigned to a particular plaintiff. It just says very clearly, punitive damages are as to these plaintiffs. There's a specific nexus between the specific harms alleged to these plaintiffs and the conduct of the defendants. So yeah, we could use a Philip Morris instruction, Your Honor, but I think the law is clear that injuries to third parties should not be referenced in any way, shape, or form. And if you have any questions, I'd be happy to answer them.
No questions. Thank you. So the court denies this one without prejudice. So certainly will consider a Philip Morris instruction and to be a little, maybe hopefully a little more clear. There's a fair argument that this is premature. So when we're going through proposed instructions and trial briefs, this is without prejudice.
Understood. Thank you, Your Honor.
Your Honor, the next one will be long. Is there any way we can do this on Friday or tomorrow or something? I don't know what the court's inclination is.
I mean, there's a reason why I've tried to speed things along, and part of that is tomorrow I have a criminal calendar in the morning and evidentiary hearing. What time does that start? At 1.
Yeah.
Friday I have something else. Approve up on Friday. And then Monday's a holiday.
So the only other thing I would ask, Your Honor, then, and we've done this unfortunately in other cases. Fortunately for you, the first time we tried this case, we had a couple of weeks, full days of this, which led into the first day of trial. I have no problem doing it the first day of trial. We got enough to work on, and quite frankly, Your Honor, I have not seen the reply brief that was filed today, because I've been working on what we have in front of us. That will give us some time. And
if you want me to do the ProHawks right now, I'm more than willing to do
I've
that.
not read, that's the thing, I've not read the reply. It came in today.
Well, we need to, do defendants want me to do the ProHawks today?
Yes, sure.
Okay, let's do those and then we're gonna call it a day.
That's fine.
And
If you want to do them all, I'm here to stay.
I'm not gonna do them all today.
Okay.
Let's see.
Can you give me a second to read it, Your Honor? I've not read the reply.
So I'm sorry, counsel, but real quick, we had a real water motion limine 34 asking clarification on, but we've kind of looked at that and decided it was denied. So I don't think you guys would object if we said we'll just take the court's inclination on that one.
Yeah, I think there was just a question about whether Mark Rich's rebuttal was.
Oh, yeah, with our punitive damages expert out, is Mark Rich's rebuttal opinion out as moved.
I think that was our only question why we were gonna talk
Sorry.
about it at all.
But yeah,
You're fine letting it rest on the papers, on the judge's inclination?
Yeah.
Yeah. we
Okay,
just wanted
subject to that clarification. Yeah.
We just wanted to know the scope of that opinion, that's all.
I don't.
So with the back and forth, we'll table that.
Thank you.
Oh.
And with that, yes, let's move to the Pro Hoc.
Get out of your way, gentlemen.
Okay, plays out about 15 minutes, defense out about 9 minutes, so what,
Your Honor, can you give me a second to read it? I have not seen it.
you've had more than a second up, so. Somebody give him the thing so he could read it, I don't, but I also have to find it myself, so.
I'll read it to him from here.
That's okay. Let's see. There are two replies to be clear apparently, but I already said this, but if there's repeating given. So my main concern is the timing. And the plethora of attorneys that have been here and those who have not been here at all, including the two Pro Hoc movements. I did read the Imperial credit case. And yeah, they talk about general rules. But they're pretty clear on. Generally, there are always exceptions, so. Welcome.
Judge, can you tell me what you mean by with your concern about timing?
Yeah, so the trial starts on Tuesday.
That's what I thought.
We got the motions, I think I signed them maybe the same day I got them, but January 5th. So 5th to Tuesday. That'd be the timing, the 2 weeks essentially. And then also the concern, like I just mentioned too, of and I'll give some more details on this. What I've experienced, there's a reason why although I can't quote myself in this particular case, but I generally will say, and I also will generally put in trial order, lead trial counsel is required to attend a pretrial conference, a calendar call. Now, I understand you're not going to call them your lead trial counsel, but what I've run into more than one occasion when somebody comes in after pretrial conference calendar call and here potentially after 2 weeks of very thorough, extensive motion hearings. More than one occasion that has led to some issues at trial which could have been avoided had the people been whatever attorneys had been here before. So that's a concern.
Gotcha. And that's what I guessed your concern was, because you talked about timing and case management.
Yeah.
And so I figured they were related. Let me go through. So I had thought that when you expressed your concern earlier today, that you were talking about the section of their brief where they have parts of the Hunwardson case.
I don't really care about that.
Okay. All right, because I was ready to go through how that was, none of that was Mr. Boho's fault. That was all local counsel's fault. In Hunwardson, we did have trouble with local counsel. And you may realize in Henry and here in Hearst, we don't have the same local counsel because of the problems that we had there. But we do. Mr. Boho was involved in Hunwardson, was involved in the trial. You know, he came in late to that case. He spent 2.5 weeks trying to get ready in that case. He's much more prepared now. He's been, and you know, that was a Judge Kishner case, and we had many more pretrial orders further in advance of the trial.
He's in a position now where he's been monitoring. I think he was here one day during these hearings when I wasn't here. And so I have Mr. Boho and I have Mr. Nicholas both here, if you would like to address them or have them address you on their preparedness for trial, Judge. Because it's, and you've read Imperial Credit. Imperial Credit came down in 2014. And I think what it was is because the Supreme Court had addressed a number of Pro Hoc Vitae issues in unpublished decisions on writ petitions in 2012, but that's back when you couldn't cite them. So the court in Imperial Credit came up with a decision that said, essentially, in my opinion, Your Honor, you treat out-of-state Pro Hoc Vitae counsel as Nevada counsel. You couldn't, if I were to hire some Nevada counsel to come in late at the trial, you would not be in a position where you could say, I'm sorry, I'm not going to honor your Nevada license.
But I think I could be if it's this late, and that's kind of what I'm trying to express, especially, you know, and whether you appeal based on me saying what's happened in other cases, fine, but this is true. And, you know, maybe anyway, you'll do what you do after, but I've had this on more than one occasion. And I'm not talking about and I probably wasn't clear. These weren't Pro Hoc attorneys that I'm talking about. I'm talking about local Nevada counsel who came in late, and by late I mean post pre-trial conference and calendar call, and post hearings on motions in limine, and then they're telling me things that didn't happen or say, you know, and these are local Nevada counsel. So when you say, well, you know, if they were local Nevada counsel, I'd have to let them in at trial. I disagree with that.
You couldn't let, you're saying you could keep them from being lead counsel. I don't think you could keep them from being counsel at a trial.
I don't know.
All right, well, let me tell you that so I think that plaintiffs have been trying to create the impression that that's what happened in Hunwertson. And that isn't what happened in Hunwertson. And I've got both of these lawyers who are willing to talk to you right now.
No, again, I said this before, and I mean this in all sense. I don't care what happened in Hunwertson.
All right.
I you know, I read these block quotes and I have no context whatsoever about who did what, and you know, they were big block quotes. They didn't, they gave me no help.
And I agree. And if you look at the attached exhibits, you can see that they were actually not indicative of something that Mr. Boho did that he was unprepared for. It had to do with filings by local counsel. What can I do to assure you that they are ready? I have them here. Let me have this.
I'm not gonna have somebody, this is not an evidentiary hearing. So I appreciate the offer, but respectfully decline, whether it's under oath or as officers of other jurisdictions and potentially this one. We're not going to do that. I don't know how to answer your question.
Okay, because Mr. Boho's been preparing for 6 weeks. And you can
So let me ask you then, in terms of timing, why? Okay, here's a question.
Yeah.
Why didn't I get these sometime beforehand, especially given that at least one, I can't remember.
Bartley applied in August 22nd.
Say that again.
Bartley Nicholas applied in on August 22nd.
Right, so let me finish kind of what I.
Oh,
was
I
gonna say.
apologize.
That's okay. I talk slow, so it's okay. Why didn't I get either or both of theirs? For example, before the pre-trial conference or before the calendar call, particularly where one or both of them participated in Hunwarts and or one of them was approved, and I forget, I don't know if that's the right word, but was approved by the state bar several months ago.
October 10th. And Barkley Nicholson explains that he was changing law firms and thought it was a bad situation where he would apply to be pro hoc viced when he was at Shepherd Mullen and switching to another law firm. And that I think they're trying to create the impression that there's some delay some untoward delay. You seem to be looking at another issue in delay. You're just saying, well, why were they brought in so late? When in fact, they weren't been brought in by the client so late. It was just finalizing the petition to appear in front of you. So they're not in a position where they're unprepared to try the case. If you want me to address all the other issues they brought up, because they realized with Mr. Nicholson, they brought up two issues. And one of them seems to be contrary to your concern. One of the issues was that he waited so late after he applied to the state bar. The other one was that he has been involved in the case, that he has been working on the case.
Oh, so again, I don't care about that.
But that shows he has been working on the case.
Okay, well, maybe I'm not. Anyway, I'll give you a minute or two more. You'll have a rebuttal certainly, but anything further?
Well, if you're not concerned about the alleged conflict that they're raising with Mr. Boho having to do with the Gallagher case, because as I've pointed out, they don't have standing to raise that issue. It doesn't affect them. They have been raising Liberty Mutual conflict issues throughout all of these cases. They raised one with me in Gallagher because I represented a Liberty Mutual insured, and Real Water happened to be a Liberty Mutual insured. This isn't a conflict. This isn't an issue. The conflict itself could not be a problem. So it comes down then to judge the idea that they claim that Mr. Boho and Mr. Nicholson violated Rule 42 and 5.5 by being involved in this case before making their applications, being involved in depositions, being involved in mediations. At the direction of Nevada attorneys, they didn't participate, they didn't practice law. It wasn't the unauthorized practice of law, but they have been involved in this case, which should satisfy your concern that they wouldn't be prepared to handle this case. Thank you, Your Honor. I said my time for rebuttal.
Thank you.
Your Honor, in terms, do you want to take this separately, Your Honor? Would that be better or does it matter?
You mean the two?
Separating the two.
I would do them both.
Okay, and Your Honor, considering that the court seems to be focusing more on time, that's what I'm gonna limit my conversation to, my presentation to. The papers will speak to the other issues. Your Honor, Mr. Nicholson applied in August, and then well, his application is October 10th, 2025. There's an August date that's also reflected in one of the exhibits to the motion it was August 22nd, when is the date of application to the state bar. And then we see October 10th, 2025, in terms of when it was approved by the state bar. I have no understanding why you wait for 4 months virtually to bring this. He missed the calendar call. He's missed all of the motions, whether or not he's been, surreptitiously listening on Zoom or sitting in the back. I don't know. But what I do know is what our rules provide. And what I do know is the experience I've suffered when lawyers come in this late. And I'm not necessarily referring to HUD Wardson. It doesn't matter given what the court has said. This is what happens, and I don't understand. And one of the considerations of the court is undue delay. And they have now a stable of 6 or 7 lawyers already involved. They're trying to bring in 2 more, and they file these motions. And this is what is so troublesome to me in terms of the timing, Your Honor. We had well over 100 motions in limine. They filed this on January 5th. We started the motions in limine practice, the hearings on January 5th. So in between, with our limited resources, you see the number of lawyers on one side of the floor versus the other.
Oh, hold on. I can't hear. Please keep it to a whisper. Thank you.
I appreciate that, John. And you know what we were doing on the 5th and on the 6th and the 7th and all the way up to today. And so this first is an unnecessary interruption in terms of the timing. This should have been done in August. The original trial date was October, if the court recalls. We moved it to January, and they wait to January 5th to do this. I didn't see any good cause referenced in the rebuttal. None. Now, I just scanned it over today, a few moments ago, but unless the court saw something, I didn't see even an attempt to provide a good faith reason for why they waited until the eve of trial. Having missed everything we've done, all the 2.47 meetings, on all of the motion practice, and now we're here battling this on the last day after all of the hearings have been exhausted on all the pretrial motions in limine, Your Honor, and the motions for summary judgment. This is not, in my opinion, good faith, and there's no excuse for the why they did it. Mr. Polsenberg, you gave him several opportunities to do so, and he's offered none. Now, he's reserved, but Your Honor, it should have been in a briefing, because now for him to try to suggest some good cause not having it in a briefing, I don't have a chance to even respond to that. So I think it's too late now to offer some good faith reason, since it's not in any of the papers that I've seen. It's not in the motion, and it's not in the reply. So Mr. Polsenberg gets up and says this should be something perfunctory. It's not. Imperial case doesn't stand that it should be perfunctory. There's a reason why it comes to the court for the court's decision, and it's in the sole discretion of the court to make a decision.
Since you're here, I know Mr. Boho participated in Hunwarts, and I can't remember, and you may or may not know, did Mr. Nicholson participate in there as well?
I don't recall Mr. Nicholson.
Okay.
What we did cite to is that we found that he may have appeared without making a formal appearance, the 22 or so depositions. We're not sure, but the depositions are not open to the public. I'm concerned that you're attending depositions not being a licensed attorney or admitted to practice in this case. That is bothersome, in my opinion, Your Honor. I don't typically, if you're appearing in a deposition and you're not licensed, you say something to someone, or you get authority from the court. I've never seen someone sit, in the wings without anyone else knowing, attending these depositions and not being admitted either pro hoc or licensed in Nevada and associated on the case. So that's what appears Mr. Nicholson has done. Mr. Boho, again, if he's working on this case 6 weeks, taking what Mr. Polsenberg said at face value, why didn't he apply 6 weeks ago? Your Honor, you cannot reconcile the arguments made by Mr. Polsenberg in support of these applications. In fact, his arguments, in my opinion, stand against of granting these applications. Your Honor, I have not seen nor heard any reason why he was working on the case for 6 weeks and didn't apply until last week. I've not heard any good reason why Mr. Nicholson has attended roughly 22 depositions quietly or without anyone knowing and didn't apply.
Well, even, I mean, that kind of goes with my, like, let's assume that as they do argue in their briefs that that the attendance is a non-issue. So let's accept that. And not focus on, whether, so let's assume it's a non-issue.
Yes, Your Honor. Your Honor, can they stop talking?
Yeah.
I can't even.
Your Honor, I apologize. I turned to Mr. Boho because I couldn't hear what the judge said, and I asked him to.
Everybody who's in the courtroom, while either counsel or the judge is talking, please refrain from speaking.
Yeah, like, I mean, if you can't whisper, don't. Especially after I asked and told, and it's 5:45. On literally the eve of trial. Okay.
Your Honor, could you repeat what you said?
I know, I'm trying.
Yeah, I could
Yes,
not
thank
hear
you, because I was
thing.
trying to remember what I said. So, okay, so let's assume that there's no issue with attendance at whatever, whether it's 1 depot, 2 depots, 22, whatever else. That seems to me, and you're probably going to say me too, but I mean, like, okay, if that is the case, then why wasn't this in front of me several months ago?
Exactly. And Your Honor, when I was listening to Mr. Polsenberg argue, I was saying to myself, I mean, how is this not some form of ambush, not just to the plaintiffs, but to the court, to wait to the 5th of January when you were working on this case 6 weeks ago? How is it not ambush to the court and to plaintiffs' counsel and the orderly proceeding of this trial when you've been attending whatever depositions? And I will accept, for purposes of this argument, let's say their attendance at a mediation or X number of depositions is fine. Let's just say on its face. Then why would you, in good conscience, hold back your applications until January 5th? Since you were already working on the case. Why do you hold it back from October 10th? You could have applied then. But to hold it back 6 weeks, Your Honor, that takes us back into October or early November. And then you hold it to January 5th? There is no good cause, Your Honor, and that by itself is alone would satisfy denying these motions. And in terms of the harm, Your Honor, because I didn't address that if I could. Your Honor, there's been, a large complement of lawyers here, both in the courtroom and on Zoom on behalf of Terribles. There can't be an argument that they're prejudiced by not having Mr. Bowe here, because if they would have had him in 6 weeks here ago. They can't make the argument that Nicholson, not having Mr. Nicholson here, would be prejudicial, because they would have had him here back in October applying. They sat on this to our detriment, to the court's detriment, and now it should be to their detriment. And I ask that the court deny their motions because it is in the sole discretion of the court and given their untimely application, John.
Thank you.
Thank you.
You have 5 minutes.
Thank you, Your Honor. Why would we delay? Why would we delay? It doesn't make, they're arguing that the court is prejudiced, that they are prejudiced because we delayed, but they can't say how anybody is prejudiced for lawyers who were working on the case. They say attended 22, monitored, didn't participate in, didn't ask questions, didn't make objections, getting prepared. Why would they delay? There's no reason to delay, but it doesn't cause any harm. They would have to show prejudice only from the delay in applying. Barclay Nicholson applied in August 22nd. Why did he wait to apply? Well, it wasn't to avoid the fee from the state bar. He paid the $550 on August 22nd. His anniversary date is August 22nd. I checked with the state bar today. He'll have to pay another $550 on August 22nd. It wasn't to save money. It wasn't to deprive the state bar of an opportunity to review. It doesn't affect them. Judge, I'll be honest, I don't think it affects you, because their failure to, it wouldn't affect under imperial credit what you have to look at to see whether they apply. Timing isn't one of the elements of Rule 43 or 42, excuse me. They come in and they say, we have lots of lawyers. Well, nobody's going to let, and they specifically mentioned 3 in their brief. They mentioned me. Judge, nobody's going to let me try a case. So here is a lawyer who's got experience with trial, who's got experience in a real water case. The case would go much better with his participation here. That I think is why he is our lawyer of choice. And under imperial credit, that has to be given the primary consideration. No, you don't. I apologize. I learned from Judge Mosley not to tell a judge you don't have the discretion to do something. But you don't have the discretion here just to say no. These lawyers comply with Rule 42. Why wasn't it in front of you weeks ago? I don't know. I started that question with the question he ended. Why would they wait? It makes no sense, but it makes no difference because they're not disqualified because of that fact. They've been preparing. They paid their state bar dues well in advance. The only issue you have is the timing of their motion. And your original thought behind that, I'm not saying you're switching thoughts. I understand thoughts evolve. But your original thought behind that was these people are coming in too late. But they have been getting ready. Why they waited? I know why Barclay waited, because he was switching firms. I agree with him. It would be untoward to move for a pro hoc vice with one firm and then switch to another firm that's involved. So that makes sense to me. They're saying, well, Dan Boho shouldn't have waited 3 weeks. Three weeks to wait from applying to the state bar to applying to the district court is not an unusual amount of time. Was there prejudice that resulted? No, there wasn't any real prejudice. And we're trying to find a lawyer to try this case. I'm not going to get into all the issues that I've been complaining about us not being ready. But here is a way that we are trying to get ready to try the case. And these lawyers are qualified to try the case, and they are our choice. I apologize for the timing of this. I don't understand it. But there isn't any real harm as a result. Thank you, Ron.
Thank you. So I'm going to repeat myself somewhat, but it bears repeating because the court's going to deny the motions. To be clear, I do not base the denial on any alleged impropriety in Hunwartson or even any alleged impropriety on attending or observing other deposition, or I shouldn't say other depositions, but depositions or mediation. That forms absolutely no basis in my ruling. I don't find that there's any improper conduct whatsoever. I mean, that I don't have anything sufficient in front of me to decide that anyway, but to be clear, a lot of plaintiffs' arguments I'm completely disregarding. So like I said, I did read and it was very helpful. The Imperial case, I'm gonna quote at least a little bit from that. Well, backing up. Procedurally, the status of that case was a little different. Unfortunately, because of the timing of the briefs, and the record will reflect all the time I've spent in here the last couple weeks, and I'll put on all the time I've spent outside the courtroom trying to get through, I don't know, 100 to 150, however many motions we've had in the last couple weeks. So in an ideal world, I would have been able to have time to pull up more details of Imperial and the procedural timeline there. I was unable to do that given time constraints. But so as noted by the Nevada Supreme Court in the Imperial case, quote, the issue becomes whether the district court may properly deny a motion to associate out of state counsel when the prospective applicant meets all of the requirements for admission set forth in SCR 42. I agree with defendant's position that that is what we're dealing with here as well. I, of course, acknowledge that Imperial, in that case, the Nevada Supreme Court issued a writ of mandamus directing the district court to vacate its order denying the motion to associate pro hoc vice counsel and to instead enter an order granting that motion. So I acknowledge my ruling is also denying pro hoc admissions, and I'm doing my best to follow the laws I understand it from Imperial credit. So a rule from that case, quote, thus, when out-of-state counsel satisfies all of the requirements set forth in the rule governing pro hoc vice admission in Florida, oh, they're quoting from another case here. In Florida, the motions should usually be granted on a pro forma basis. But they do go on, similar to that THI Holdings case, and they say, quote, but the district court's discretion in this regard is not unlimited. So I acknowledge my discretion. I have discretion, but it's certainly not limited. Certainly not unlimited. It is limited. Continuing on, quote, instead, the district court's discretionary power is subject only to the test of reasonableness, which requires a determination of whether there is logic and justification for the result. The trial court's discretionary power was never intended to be exercised in accordance with whim or caprice of the judge, nor in an inconsistent manner, close quote. Quote, stated another way, such discretion is improperly exercised when the judicial action is arbitrary, fanciful, or unreasonable, or where no reasonable person would take the view adopted by the trial court, close quote. The court holds they adopt the position taken by the THI Holdings Court, quote, and conclude that when prospective pro hoc vice counsel satisfies all of the requirements for admission under SCR 42 and a proper motion to associate out-of-state counsel is filed in accordance with that rule, the motion to associate should generally be granted as a matter of course. So I am emphasizing, and I'll put it so it's in a transcript, emphasizing their proper motion and generally granted. Continuing on with the quote, and when considering a motion to associate, the district court should generally, emphasis, should generally limit its analysis to the requirements for pro hoc vice admission set forth in SCR 42, such that the consideration criteria outside those set forth in that rule may well constitute an arbitrary and capricious exercise of the district court's discretion, close quote. I do not have the same concern that the district court in Imperial Credit had that the trial would be delayed. That's not part of my ruling. I'm not putting the burden that the district court in Imperial Credit put on counsel to demonstrate that out-of-state counsel is more capable of handling the case than local counsel. That's not any part of my reasoning here. Rather, I do have discretion. It is limited discretion, and here I believe and rule and find that my discretion to deny the motions is appropriate. There's no good cause shown for the extremely late timing of the filing or filings. They were filed January 5th in a trial set to begin on January 20th. They were filed well after the pretrial conference, well after the calendar call. And there's no, I mean, there's not just no good cause, there's been no reason provided by movements for that extreme untimely delay. It is undue delay, to be clear. Whether, and I'll even assume the delay was not intentional. But even assuming that, this is, and I don't use these words lightly. But it is on the eve of trial for no reason whatsoever. And so it is an ambush on the court. It is a sandbag on the court. There is, as I noted, reasons why I whether verbally or in writing or both, require lead trial counsel to appear a calendar call, because I have had issues where attorneys, not even, and Nevada attorneys, like I said, come in late. And there's no reason for, you know, even if they were Nevada attorneys, to come in this late as requested. Either or both could have easily applied to the Nevada State Bar and moved before the court much months. So to be clear, months sooner than they did. The explanation for the delay with Mr. Nicholson between applying, according to my notes, although my note could be a little off, applying August 22nd, being approved by the Nevada State Bar on October 10th. Switching firms is certainly not a good cause nor a reason to delay getting this issue in front of me. And to be clear, you know, plaintiffs have an opportunity to respond, which they have, but they, you know, a lot of their arguments, like I already said, I disregard. But the fact that, you know, let's assume then that they have, quote unquote, and either or both have been involved in this case for some time, and assume that notwithstanding that, they were not practicing law, which I probably agree with that anyway. That actually cuts against their position of, well, we're ready for trial. Well, if that's, you know, this should have been done some time ago. You know, now we're at 6:05 p.m. what, 2 business days or whatever before trial's supposed to start. Now, to be clear on that though, you know, I did try to get this in front of me before, and I will acknowledge defense counsel's professional courtesy in working with plaintiff to permit plaintiff to respond to it. But let's assume even this hearing happened a week ago. The issue really is the late, untimely, without good cause filing on the eve of filings on the eve of trial. So I believe, and so rule, that my limited discretion in this regard is proper. Under the totality of the circumstances, it's proper, it's reasonable, it is not arbitrary nor capricious, it's not on a whim nor in an inconsistent manner. On that point, you know, just as an aside, I've granted, I don't know how many pro HPJ admissions in other cases. And I acknowledge the rule again, generally should be granted as a matter of course, sorry, and should generally limit the analysis to the requirements for the rule. And to repeat, I find rule they did comply with the rule on its face. However, under the circumstances here, which I've hopefully detailed, I'm denying it for reasons that aren't set forth explicitly in the rule. We'll definitely need a very detailed order submitted to everybody on the other side for review and approval.
Of course, Your Honor. Thanks for staying late.
Well, and now we have to still, we still have to talk about, so we're set to start trial on Tuesday. And I was talking about my schedule. What time are we scheduled to start on Tuesday? We're probably going to actually start at 1:30. We'll clarify that for sure, but we will not start at 10:30, to be clear. In terms of the trial and the voir dire. Given everything, I haven't even had a chance to look at any of the excusals. I don't think we put any of that on the record. We have a bunch of things that I haven't ruled on yet. You all haven't argued. But unfortunately, I don't have tomorrow or Friday for you all. So maybe bear with me. So need to pull up my Monday calendar. Or I'm sorry, my Tuesday calendars. Yeah. Criminal hearings. So let's come in, not for jurors being in the courtroom, to be clear, but let's come in here at 11 on Tuesday, the 20th. And hopefully we can maybe talk about some of the outstanding issues.
Thank you.
Thank you.
See y'all on Tuesday.
Thank you.
Thank you.
Thank you.
Appreciate it.